My lord, my lord, may be permitted to mention one matter. Bill in connection with appeal for including the list.
Yes. Item one. Notice. Patient, what did he say? When the victim.
My lord, yes, corporate, my lord, 164 is very serious in nature. My lord will go through
Has
154.
the victim, did you intimate the victim, someone to represent through the,
Just now they have come.
so should,
Yes,
yes,
the petitioner is about 70 years old. But his neighbor of the director complaint, Vijayan Roy. But what has happened, Vijayan Roy is lodging a complaint on 15th May. Intel alleging that his daughter, 15th May, remember? 13th May, his daughter was going to raise cow in an open field.
stop the live stream.
His daughter was going to raise cow in the open field. The accused person has embraced her and attempted to refuse. When the girl shouted, he ran away. He ran away. This being
I'm for the petitioner, you know. The case relates to 376T. I have already intimated the matter to the, then the notice was duly served. Actually, my lord, both commission is not present, so without affirmation, I have
Yes. Why oath commissioner is not present?
When it comes-
11. He comes at 11.
He comes at 11.
Huh?
He comes at 11, which
Why?
junior stated.
Who is this oath commissioner? Who is this oath commissioner? All the oath commissioner. All the oath commissioner.
Already, this application was earlier not placed on 12th of
Let me finish.
12th
I
of
will,
October 23.
let me finish, sir. Then you will, will on.
Yes, tell us.
164 fifth present.
My lord, may I submit something?
Yes, yes, please.
My lord, the present petitioner and the alleged victim, both of the student of Jalpaiguri Law College.
Hmm.
And they had relationship.
Hmm.
And this is the identity card which I obtained from the Jalpaiguri Law College. The both the petitioner was 19 years old and the alleged VG is the 18 years old. Actually, they had love affair. And they were in their native place, in a dark place. Some people caught them red-handed. I'm very fairly submitting.
Hmm.
Subsequently, the father of the alleged VG lodged a complaint stating internally the present petitioner, along with others, committed sexual assault to that lady. Both of the students of W Law College and they have intimacy since long.
Petitioner
And
content.
he is one indulgence, your lordship.
There
I am in custody since near about 187 days.
Petitioner is
one
in
by one rape.
custody for 187 days. He submits that he and the victim are college mates. They are pursuing the college mates and are studying at Jalpaiguri Law College and are studying in the same college. It's the allegation of they were caught in a compromising position in order to cover her embarrassment. He has been falsely implicated in the offense of forcible rape. He prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record, including the statement of the victim girl. She stated that she had been forcibly raped by the petitioner
And his friend Vishal.
with the assistance of co-accused. The manner and circumstances in which the victim alleges to have been raped with the assistance of a co-accused does not support the defense plea of voluntary intimate association between two persons. With regard to the false plea, with regard to the submission that the case was concocted in order to save embarrassment is also not borne out from contemporaneous records. Under such circumstances and in view of gravity of offense, we are not inclined to grant bail at this stage.
Grateful, my lord.
Charge sheet filed.
Charge sheet file, charge frame.
Charge framed. We request the trial judge to examine the victim at the earliest. After her deposition, you may come. If you can bring out something in the course of process.
Lordship, that is subject to your lordship, that is maybe mentioned in the order sheet, otherwise.
What mention in the
After
order sheet?
they recording the.
All right, we'll mention in the order sheet if the victim supports, no bail will be granted. All
No,
right.
no.
Then
Maybe
what is sauce for the goose is sauce for the gander. If we record that a clear defense version probably realized during trial entitles you to a second consideration. Similarly, a consistent version should disentitle you. Then why should we record anything? Show us previous intimacy, show us a WhatsApp communication of friendship. We will acknowledge, but just oral statements will not do. Oath commissioner college oath commissioner Joydeep Babu. This is the oath commissioner. He talked with me at 10 AM. So the oath commissioner is present. Correct? And we do not appreciate a very experienced lawyer making incorrect submission before the court.
I do not never meet with him. He met with me.
The thing is that you should generate that feeling to your young friend.
Yeah.
That a young lawyer must be first honest before he becomes learned in law. Why, sir? Why do you make an incorrect statement? If you have not got it affirmed, there is no difficulty. We will look into that problem otherwise, but don't try to make incorrect statements. You will be caught out. Unfortunately, what would happen is the fate of the litigation will take its own course. But the impression that you generate on the bench will remain with you forever. Is that good?
Your Honorable, sir.
Then please first
Dr.
thing,
Paswan in court.
tell us that you have this difficulty. That is why it is no difficulty. We will ensure. Mr. Bhomik said, we do not appreciate that you make a statement before one of our officers saying that he does not come to court till 11. Whereas he had talked with me at 10 a.m. Then, next matter.
I may excuse, Lordship, actually, the wrong information I have received.
You are not the person we are concerned. We are concerned with this young man who ought to have a career in the bar. And that is where your guidance as a senior should come in. That don't give me incorrect information just to avoid situation. That is far worse than facing the situation. Next.
I am appearing for the petitioner.
Yes.
So this petitioner is Genarian. It is about 78 years. He is
Please close the streaming. Whenever we are doing a POXO case, victim is present without instruction, close the streaming.
the maternal grandfather of the victim.
Their thing is gone.
আছে আচ্ছা বলুন বলুন
কি বলবো?
my lord, am I audible, my lord?
কালকে নিতে বলো।
He's inside. ওদের লাইভ স্ট্রিমিং পজ হয়ে রয়েছে, ওদের স্ট্রিমিং পজ। Their live streaming পজ হয়ে গেলে জজ পজ করে দিয়েছে নাকি? তাহলে তো আমরাই আউট হয়ে গেলাম, তাহলে আমরা বলবো কি করে? গিয়ে করতে হবে, তাহলে তো আর সমস্যা। পক্সো বলে লাইভ স্ট্রিমিং দিচ্ছে না, পক্সো বলে লাইভ স্ট্রিমিং দিচ্ছে না,
তাহলে কি করবো?
কিছু করার বলুক অন্তত, কি করবো তাহলে? ও ভিকটিম কোডে তো লাইভ স্ট্রিমিং পজ করে দিয়েছে। ডে আফটার টুমরো, যে তাহলে তো গিফট না করা ছাড়া তো দিনের চয়েস নেই। ভিকটিম কোডে আছে, লাইভ স্ট্রিমিং পজ করে দিয়েছে। আইডেন্টিটি ক্লোজ হয়ে যাবে, ওই জন্য হ্যাঁ ঢুকতেই দিচ্ছে না, আমাদেরই বার করে দিয়েছে, আমরা ঢুকি এবার তার বিপদ হয়ে গেল। রেকর্ড হচ্ছে তো পক্সো, যে গিয়ে করতে হবে, দেবে না ভিকটিম।
তাই বলো শুক্রবার দিন চলে যাও।
ভিজি আছে না কোর্টে, এই আইনটা না কেন ভালো স্যার
Mr. Basu is saying that can an adjournment be given in another day because he cannot hear.
What he cannot hear, ask him to remove the pause. What he can, how can he cannot hear?
He has muted us. He has muted us.
The other end asked his junior to unmute us. We can tell them that we can hear them loud and clear.
Very well. I am making my submission.
Yes,
Petition Jalpaiguri, aged about 78 years.
yes.
He is the maternal grandfather of him. But in August 2019, the victim was staying with the petitioner and his wife. And it is said that on 25th of August 2019 and again on 4th of May 2019, the petitioner sexually assaulted her. And this is the long and short of the story. The trial has started. The victim had already been examined. The petitioner's the wife is on bail. 16 witnesses are to be examined. The victim has already been examined. And the victim was, the date of birth of the victim is 28 July 2001. So as on the date of the first incident, when the sexual assault took place, the victim was a major. This is one aspect of the case. Another aspect of the case is the petitioner has two daughters.
What is the date of birth, Mr. Basu?
Date of birth is 28 July 2001.
2001. So in 2019, according to you, was above 18.
Above 18. And not the petitioner has two daughters. The victim's mother is the younger daughter, and the elder daughter's name is Antura Chakraborty. But on 3rd September 2019, the petitioner executed a will in favor of Antura Chakraborty with regard to his property at Salt Lake. And thereafter, all these incidents are cropped up. The FIR had been lodged on 4th of December 2022, more than about how many years after?
3 years.
About 3 years after. 3 years after the incident. Now, this is the long and short of the story.
All right. Mr. Bishwas, what do you say?
Lordship, on earlier bill application, in February 8, 2023, the issue of this property dispute has already been dealt with. So this is not a new point, Lordship. The evidence of the victim has already been recorded, Lordship, and most important thing and most alarming thing is that this petitioner is calling the victim and her family from the jail and giving threats.
Where
There is the telephone number.
Then the city also tells that.
If he is released on bail and she is studying in Diamond Harbour in a medical college, she will be exposed to directly to the accused. Not she will be under the control of the accused and
So why she is how the petitioner is accessing a mobile phone from the jail?
he also supports.
We know. Where is your report with regard to his use of mobile phone from the jail? Mr. Vasu, your client's conduct is very unfortunate.
No, but can my
We would have
substantiate this allegation that he is threatening the victim from jail?
How is he calling the victim from the jail?
The Let my learned friend substantiate it that I am calling the victim from jail.
The
Merely
report
making
is
a
there.
complaint will not do.
But at the first instance, my lord, when she,
Well, let my learned friend substantiate.
two occasions, my lord, bail has been turned down by the.
One second. This phone call came in. When were you arrested?
On the 8th of December 2022.
8th of December. On 17th of December, a phone call was made from a phone number of 1746 to a number 5118, which is the mother of the victim girl.
Huh.
That is the report given by
Mother of the victim girl is my daughter.
Hmm?
Mother of the victim girl is my daughter.
Yes, but then you are calling the mother of the victim girl from jail. She is a witness.
Anyhow, I didn't know anything
Then
about it.
let the mother be examined
December
thereafter.
last year.
That's in last year.
Thereafter, no phone call.
Mother, when are you going to examine the mother? What are the other witnesses apart from this victim?
1611 is fixed for the next examination. 1611.
1611 for whose examination?
1612.
1612, whose?
1612.
8th of January.
8 January, who are to be examined?
8th of January.
Mother.
Mother, right?
Mother and any other relations are witnesses?
Mother and father.
Father and father.
So you have the exam, Mr. Basu.
Yes.
What we propose is since there is an allegation of your influencing the mother, let the mother's evidence be recorded first, because the victim has already been examined. So the chance of influencing the victim hereafter will be quite bleak. Now, if there is an allegation that you are trying to influence your daughter not to support the granddaughter, let the parents of this victim be examined, and then we'll consider your bail prayer.
As you lordship.
We direct that petitioner is a septuagenarian. He contends he contends in December 2019 he executed a will bequeathing his property to
September 2019.
September 2019 he bequeathed his property to one of his daughters. In retaliation, he has been falsely implicated by the other daughter. He has been falsely implicated by the granddaughter born from the other daughter who was deprived in the will. Full stop. Victim has already been examined. Accordingly, he renews his bail prayer. Learned APP opposes the bail prayer. He contends petitioner had contacted the mother of the victim. He contends petitioner had contacted the mother of the victim from jail. Full stop. Parents of the victim are yet to be examined. Possibility of influence upon them cannot be. There is high possibility of their being influenced if the petitioner is released on bail at this stage. Learned lawyer for the victim also opposes the bail prayer. We have considered the materials on record. Victim is the granddaughter of petitioner is the maternal grandfather of the victim. It is alleged that he had subjected the victim to penetrative sexual assault in October, na?
August.
August.
In August 2019. Full stop. Huh? You are there, why she will say something. If factually incorrect, indicate to us. It's a continuing offense. It happened earlier also. What, Mr. Bishas, you did not take instruction?
Yeah, I did.
Then?
Well, she might have written something which she wants to hand up to your lordship. I am unaware of it.
Why?
She's.
You are his lawyer, you are her lawyer. How can you be unaware of contents? It's your duty to examine.
Lordship, yeah.
Yes. Penetrative sexual assault. Lastly, in August 2019, full stop.
In May,
FIR came to be
the first.
FIR.
On 4th of December 2022.
In May 2019. FIR came to be registered in 2022. Full stop. Though the delay in the first information, in registration of the first information report, may be due, delay in the first information report in lodging FIR may be due to the close relationship between the parties. However, it is contended that a dispute over bequeathing properties had cropped up in the family in 2019. Full stop. These issues may be required to be thrashed out in the light of the evidence on record. One of the vulnerable witness, though the victim has been examined, her parents, we are informed her parents are proposed to be examined in January, on 8th of January 2024. Stop. Materials is placed on record that petitioner, while in jail, had contacted the mother of the victim over mobile phone. In order to, under such circumstances, we do not consider it prudent to enlarge the petitioner on bail at this stage when other vulnerable witnesses, that is parents of the victim girl, are yet to be examined. Hence, we are inclined not to allow the bail prayer at this stage. We request the trial court to examine the parents of the victim on the next date fixed, and if it is unable to do so due to circumstances beyond its control, positively within a fortnight thereof, without granting unnecessary adjournment to either of the parties.
But the victim has not been served with the copy of the evidence collected during the investigation, lordship. As per the section 25, subsection 2, she is unable to represent her case, and a lawyer for the BLS may be appointed to represent her in the trial.
We also direct the trial court to arrange for, to take steps so that the victim is entitled to appear in the proceeding through a lawyer, through an empaneled lawyer, through a lawyer of her own choice, or through a lawyer empaneled from in the District Legal Services Authority, to assist the public prosecutor.
And the copy, Lordship.
That you get from the public prosecutor. You're not required to
may
be
I just-
served. You ask the public prosecutor will give you the copy. Who is the public prosecutor in this case? Why the victim is not getting adequate assistance from the public prosecutor?
Also, also is there.
You please inform him. If he wants to remain a special public prosecutor in the boxer courts, he should entertain the victim and see that she is properly represented. There will be a lawyer who will assist the public prosecutor in this regard.
Lord, may I just say a few words? Lord,
Yes.
I abide by your decision.
Yes.
Lord, this is the third application. When the
Yes.
earlier two occasions, Lord, when the bail application was heard, it was never communicated to court that in the month of December 2022, the petitioner telephonically communicated, contacted his daughter and had a
Mr. Basu,
discussion.
that is why we have looked into the records. There is a clear report.
So, Lord, on the earlier two occasions, Lord,
Oh, that
This
is
was-
because you had friendly opposition, maybe. We are taking judicial notice of the nature of opposition which is extended, assistance extended on behalf of the state.
very well, Lord. It's all right.
Always.
Yes. Next matter.
Item number 4.
I am for the petitioner, your lordship, but service has not been completed. I am in.
State, your lordship.
Lordship, this is the status.
One
One indulgence I am seeking your lordship. That I am in custody more than 867 days. Maybe I may be asked to produce the VG.
Why do you produce the VG? Where is the statement of the VG?
My lord, I am in custody since 800. Now kindly.
Lord, the 164 statement.
Now, my lord, kindly see. The FIR. Kindly see.
Page 6, sir.
Page number 10. Kindly see your lordship. Kindly see the page number 10, the written complaint.
Mhm.
There was an alleged incident of 9 to 10 months prior.
Hmm.
And it is also been avoided in the FIR. They are well acquainted with each other and they fled away. And so if I assume the story of the FIR not admitting,
Hmm.
they are staying together in a several
All right.
rented houses.
Yes, give the notice to the victim. Officer in charge, IC so and so shall notify the victim. Petitioner submit that there is a love affair between two young persons. He prays for bail. IC shall notify the victim with regard. Jalpaiguri PS shall notify the victim with regard to pendency of proceeding and the next date of hearing. Matter will come up on Friday.
My lord.
If possible, Thursday, because
Thursday.
if the victim doesn't come, I am in custody more
If
867
victim
days.
doesn't come, we'll reject your prayer.
Well,
We
not
can't, we
not
have
a
need,
single time. 4 times.
we need.
Instead of receiving summons, she did that turn up with my child. I've also added the.
We want the victim to be present before us. You're telling the keep it on Friday. Let us see.
As well.
Next.
Item number 5, I'm attending. Showing that item.
Yes. Statement of the victim.
Can you see the one charge sheet 4 and medical?
Page.
Lord. 154 of the victim by at page 32. 32. To the bottom.
All right. You give notice, victim notified?
Yes, sir. Item bags. I have sent for
I-
item bags.
So it has not been notified. I see. Bhaktinagar Police Station shall notify the victim with regard to pendency of the proceeding and next date of hearing. She shall also be notified with regard to the with regard to her right to participate in the proceeding. Matter will appear on Friday. Next. Evidence shall be kept on record.
My lord, I am on the petition of this under section 300, I am going to stay pardon for. Custody about. My lord, I am paying for my lord, I am paying for my lord 1 day accommodation, my lord, CD has just been received this time.
How long you are in custody?
My lord, 4 months, 27 days.
4 months, 27 days.
And my lord, charge was framed and my lord. Next. My lord, day after tomorrow, my lord, is fixed for my lord evidence.
All right. It is contended on behalf of the petitioner that there was a sudden quarrel over labor payments. Petitioners did not intend to commit murder. They pray for bail. Learned lawyer for the state submit date has been fixed for recording evidence. We have considered the materials on record. Incident occurred in the course of a sudden quarrel over labor payments. To stop, keeping in mind the aforesaid fact, and as there is no possibility of the petitioners absconding or evading the process of trial, we are of the opinion further detention is not necessary and petitioners may be granted bail. Hello, 10,000 people. Yes, next matter.
May I please your lordships? Well, this is a case registered under section 302 and 34 of Indian Penal Code. My lord. My lord, the case is absolutely based on circumstantial.
His day has yet not been arrived.
Tomorrow, not today.
This is my renewal of pair of my bail. My lord, statement of co-accused I implicated in the instant case. I am now in custody 112 days. And there is no other affair to implicate me, my lord. Only statement of co-accused, no CDR, I think, my lord, no bank transaction, my lord.
Yes, any development since rejection of bail?
My lord, there is criminal antecedents of there,
All right.
habitual offender, and my lord, previously the bail prayer was rejected on 21st September 2023.
At the time I was 31 days.
61.
My lord, in this calculation, I am arrested on 20
Okay.
July, my lord.
Petitioner is in custody for
112 days.
112 days. It is contended there is no development in the investigation disclosing his involvement in dealing in narcotics. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. He contends petitioner has criminal antecedents. We have considered the materials on record. Complicity of the petitioner transpired from statement of co-accused before police officer, which is inadmissible in evidence. In view of the nascent stage of investigation, the bail prayer of the petitioner was turned down in September 2023. Thereafter, investigation has progressed for about 3 months, but prosecution is unable to place before this court any legally admissible evidence which would establish complicity of the petitioner in the transaction in question. Under such circumstances, we are of the opinion petitioner has been able to rebut the statutory restrictions under 37 of NDPS Act and may be released on bail subject to conditions. 10,000 to sureties, meet officer in charge once in a week under further orders. Next.
Item number 10.
No, I have filed the report. One accused person arrested and one surrendered.
But this is the second application of anti-Semitic.
All right, they have been arrested.
One accused person arrested and one female surrendered.
All right. Petitioners have been arrested. Now, petitioners have already been arrested. Hence, the application is dismissed as infructuous. They are at liberty to pray for regular bail, which if filed will be considered in accordance with it.
Gratefulness.
Isn't it? Next.
Item number 11, I beg to appear on behalf of the petitioner, your lordship. The allegation is under section 306 and 34 of the Indian Penal Code, your lordship.
Any suicide note is left behind by the husband?
Not husband, your lordship. Both of them are of 19 years of age, your lordship. They are classmates, your lordship, and subsequently.
This boy had a love affair with the petitioner.
Admitted.
Any suicide note?
No, lordship.
No suicide.
Suicide. No, lordship.
Petitioner submit there was love affair between the victim and between herself and the victim. This did not fructify in marriage. Out of depression, he committed suicide. She prays for pre-arrest bail. Learned lawyer for the state opposes the prayer for pre-arrest bail. She contends petitioner and her family members had ill-treated the victim. As a result, he committed suicide. We have considered the materials on record, including statements of witnesses. Witnesses claim victim was ill-treated by the petitioner and her family members, but he has not left behind any suicide note. Full stop. Whether the conduct of the petitioners would constitute abatement to suicide. Abatement to suicide may request to be assessed in the light of attending circumstances during trial. Full stop. Petitioner is a lady and there is no chance of abscondence. Under such circumstances, we are inclined to grant and substitute 10,000 to sureties. Subsection. Next. But yes, any suicide note? Petitioner submit there was matrimonial dispute between the couple. Victim committed suicide. Ingredients of offense punishment under section 306 of the Indian Penal Code are not disclosed. He prays for bail. Learned lawyer.
Lordship, 161 statements, allegations against the.
What is the allegation?
Allegations, your lordship,
Illicit relation.
no lordships.
Then
Lordships, allegation is not care.
not care. Who is going to what care?
ঝগড়াঝাটি,
Jhogra jati.
ঝগড়ার মধ্যে ঝগড়া
Then
ছিল।
is this a ground?
Yes.
Listen, for the husband, the advantage of 113A is not there. That if there is ill treatment or demand, first there is no demand of dowry. Then we have considered the materials on record. Statements of witnesses show there was domestic quarrel. Whether domestic strife per se would constitute abatement to suicide request to be assessed at the appropriate stage of the proceeding. Be that as it may, victim did not leave behind any suicide note. Full stop. Keeping petitioner is a lady and there is no chance of abscondence. Accordingly, we are inclined to grant answer.
Lordship, my object.
Yes, yes. Next. Illol Shahapodda. 300 to 307, we are going to give you anticipatory bail. Natural death.
And I have been the wife of the accused number 2. There's the dispute, they enter into the lab and associate 1 and 2.
Mr. Who is for state? Mr. Vishwas. He is saying that she did not share common intention to murder.
Item 13.
Yes.
She did.
Did she participate in the assault?
No, Lordship, but
Then
there's something. I'm showing. May I hand the Lordship?
The role that I will also see this.
you are whose wife?
Punjab's.
Panjabali. His exhortation, you surrender. Petitioner submit that she is the wife of a co-accused. She has been falsely implicated. Out of grudge, she prays for anticipatory bail. And a lawyer for the state opposes the bail prayer. We have considered the materials on record. Statement of witness show petitioner accompanied the other accused to the spot. She had exhorted others to kill the victim. In view of the aforesaid circumstances, in view of the aforesaid circumstances and gravity of the offense, we are not inclined to grant anticipatory bail. Next. Yes,
Your Lordship, item number 14 in this matter, Your Lordship, the consignment has not reached the victim, Your Lordship.
yes.
It will be reaching by tomorrow, Your Lordship.
Who is for state?
I'm for the state, Lordship.
Yes, what is the
And
statement?
allegations, 164 statement, clear stated the name of the present petitioner, Your Lordship. And there is one eyewitness also.
Your Lordship.
She also stated before the magistrate, under section 164, that at the time of offense, she saw the incident, Your Lordship.
May I, Your Lordship?
Why such a big delay in lodging FIR?
Yes, Your Lordship, there's a
If
huge
they
delay,
saw the
27 days.
petitioner victim entering,
Your Lordship, there is a long awaited dispute between the family regarding job in the tea garden. And this is nothing but a counterblast of the FIR lodged by the mother of the petitioner.
where is that FIR by the mother of
Lordship,
the petitioner?
Page number.
All
13,
right,
Your Lordship.
you have sent notice to the victim.
Yes, Your Lordship.
Okay,
Age of the way.
give notice to the victim yet? Officer in IC Malbajar, right? This is Malbajar police station.
Yes, Your Lordship.
Malbajar police station shall notify the victim with regard to pendency of the proceeding and the next date of hearing. Matter will appear on Friday. Friday.
May I, Your Lordship, one more ground, Your Lordship, the de facto complainant has stated in the FIR, the petitioner, mother of the petitioner, that they have blackmailed them, that there will be a false case registered against them. And there is a reflection.
We take into consideration all these facts, let the victim be notified. Next. Yes.
498 3 and 4 Dowry Provision Act. Petitioner is the husband, but he is posted in Meghalaya. He is working in BSF. But for that reason, he could not comply the 49 and only for that.
Or let you meet the investigating officer.
Yes.
Petitioner is a member of BSF. He contends that allegations of torture are out and out false. He is ready and willing to cooperate with investigation. He prays for ancillary bail. Learned lawyer for the state opposes the
41 is served upon the petitioner, but it is not.
learned lawyer for the state opposes the prayer for ancillary bail. He contends petitioner did not respond to the notice under section 41 capital A CRPC. We have considered the materials on record. Allegations of torture are general and omnibus. Good stuff. It is contended petitioner is a member of BSF and was posted at Meghalaya. As a result, he was unable to respond to the notice under section 41 capital A CRPC. Keeping in mind these facts, we are of the opinion, though custodial interrogation for progress of investigation may not be necessary, petitioner requests to cooperate with investigation in accordance with law. 10,002 sureties meet investigating officer once in a week until further notice. Next. Yes. Give notice. No. Matavanga shall, IC shall notify the victim with regard to pendency of the proceeding. Next date of hearing, matter will appear on Thursday. Thursday. Next. Anticipatory bill is board. List of anticipatory bill. Yes.
There was no contract on 10/8/2023. The application under this contract was signed. My contract was small and there is no indication. There is delay in
Yes.
My lord, this is the last scene together.
What last scene?
My lord, this petitioner, my lord.
How did he die?
My lord, he died by drowning, and there was a, my lord, injury in the backside of the head as well. That is in the postmortem. And my lord, these petitioners, my lord, they went to the house of the
Patel Rai for marriage invitation.
Yes, they have had a hot altercation took place with the
Any witnesses there?
My lord, 161 statements have been taken, my lord.
In the marriage ceremony, there will be other witnesses.
But it's birthday ceremony of the daughter.
Right, so there will be other witnesses.
Those who are present, my lord.
There is nothing. It's hardly anything. Let us see the postmortem report.
Page 40. But one thing, Lord, we have noticed some discrepancy in the postmortem report as well. This is a male person, but in the description of body, Lord, written as female subject.
Good. Get a clarification. During hearing of the application for ancillary bail, it appears that the postmortem report is anomalous. Although the postmortem pertains to a male victim, is said to pertain to a male victim, the description in the in column 1, describing the deceased, it is the subject is referred to the body is referred to body is described as that of a female, full stop. Investigating officer shall submit report, shall record further statement of the, seek clarification from the medical officer who conducted the PM report and submit report before this court. Matter will appear on Thursday. মদ খেয়ে এসেছিল, সেখানে ঝগড়া করেছে, তারপরে চলে গেছে, এরপরে তো আর তোমরা দাঁড়াতে পারছি না, তাহলে ওরকম কি করে এখানে মার্ডারের কেস আনবে? Yes, Mr. Bowman.
This case relates to 325 and 379. Can you the case number 9?
325 and 329. You are an extortionist. You are an extortionist.
No.
Family member.
That is not. That is the, they are the both the tenant of each other.
Tenant, how can they be tenant of each other? They are co-tenants under a common land.
Lordship,
Tenants of each other. Yes, nature of injury.
nature of injury grievous, but it is 325 here.
All right, we
And,
have considered the materials on record. Petitioners are co-tenants. There was a quarrel, full stop. Whether injuries are life-threatening may be assessed during trial. Keeping in mind these facts, we are of the opinion custodial interrogation is not necessary and petitioner may be granted and substituted. 10th. Next.
But I have a petitioner, my lord, this is the third application before your lordship.
How this man could prefer a third application?
My lord, the
First, let us understand this.
Yes, my lord. Well, the first paragraph, my lord, of my application.
Ah.
Well, the POXO 8, my lord,
So?
victim has not been served.
What is served? First, we will serve the police officer, then the victim will be served. Yes, why this man has not been arrested? Huh?
Lordship, charge sheet submitted in the 2000.
Why this person has not been arrested? This is a subsequent application for anticipatory bail. Is the investigating officer present?
Yes, sir.
Yes, what steps she took after the rejection of anticipatory bail by this court? So what steps did she take to apprehend an absconder? Proclamation, attachment, any prayer was made? Then let us suspend the investigating officer.
Warrant of arrest is granted.
Then if warrant of arrest cannot be executed, what is the next step? Huh? We are keeping it day after tomorrow. Either steps are taken or she will be suspended. Inform her.
Yes.
This is a subsequent application for anticipatory bail. Investigating officer is present but is unable to explain why, in spite of rejection of prayer for pre-arrest bail, no appropriate steps for apprehension of the petitioner was taken. Report be positively filed by the adjourned date, day after tomorrow.
But 20 minute I am for the petitioner.
Yes.
But am I audible?
Yes, very much.
Milord 408, 420, 468, 120B, Milord, all are my state travel offense. Milord, the principal accused, he is Nawal Agarwal. Milord,
22.
Mr. Mojumdar, yours is 22.
Oh, I'm sorry, Milord. I'm extremely sorry, Milord. I'm
Yes.
extremely sorry.
Yes.
Section 6, madam, there is a marriage, madam, I are not yet received. I can.
Whose marriage? Huh? There is a marriage? Who? Yes, madam. He's saying that they have married each other.
Yeah. Lordship.
So give notice to the victim and find out whether she opposes the prayer. Huh? Officer in charge, Gokshadanga, shall notify the victim with regard to the pendency of the proceeding and the next date of hearing. She shall be also informed of a right to participate in the proceeding Thursday.
Grateful, Lordship.
Next.
My lord, in item number 21, I beg to appear on behalf of the petitioner. Am I
Yes.
audible, lordship?
Yes, you are audible.
My lord. My lord, the allegation against the petitioner is under section 188 of IPC and section 14C of Foreigners Act.
Then
Now, it all started from an abhorrent incident wherein, my lord, after India lost to Australia in the World Cup final, some Bangladeshi nationals made some unfortunate comments on the internet, and reacting to that, the petitioner number one allegedly made a comment on the internet on a social media site stating therein that the hotels in Darjeeling will no further allow Bangladeshi nationals to be board over there.
yes,
Now, starting from therein, my lord, the Hoteliers Association of Darjeeling intimated the petitioners and they directed them to take off the social media post, which allegedly the petitioner number one did not. And as such, a complaint had been lodged against the petitioner by one of the hoteliers, and subsequently a suo motu complaint had been lodged by the local police, a police official, alleging therein that when he made a random visit to the hotel, he found at least passports and other details of 3 Bangladeshi nationals, wherein certain certain official formalities had not been done, which according to the official were in breach of section 7 of Foreigners Act and section 14(6) of the Foreigner Registration Rules. And as such, this case had been started. The petitioners are all from Burdwan district. They have just taken a hotel on lease at Darjeeling.
what post you upload?
May I hand it over to Sidhu? The Facebook post, my lord, has this.
My lord, he posted
That Facebook post has been taken down?
Now it has been taken down. It has now been taken down. It is alleged that some local media took up the news and made the news which affected the hoteliers of Darjeeling. That is the principal issue.
You are the owner of Bangladesh Hotel. You are the
My lord,
owner of Hotel Tuxang.
My lord, I am the leaseholder.
Right. You are the leaseholder of Hotel Tuxang.
My lord.
You say that there will be no booking of Bangladeshis in the hotel.
My lord. My lord.
Right.
That is the issue.
So, and thereafter,
first Darjeeling Hoteliers Association, actually 2 cases were filed, my lord. One has been listed on today, that is 985. The other one being 984 has not been listed for whatever reason, I don't know. CRM 985 is before your lordship.
so who is this 33006 number? The posts sent?
My lord, these are my lord, the leaseholder of that, my lord, the hotel, my lord.
33006.
Okay.
These posts. Who uploaded these posts?
My lord, in brief, the fact is that the petitioner got irritated by some of the reactions and conduct of some Bangladeshi nationals.
Very good, very good.
And getting emotional, he made this post, my lord.
Who are the persons who uploaded this post?
His phone number, my lord, probably belongs to, my lord, the one of the, my lord, the accused. One of the accused, my lord, being the petitioner here.
So he is the owner of Tuxang. We don't understand.
But, my lord,
What is your case?
But, my lord, they are the leaseholder, my lord. They are the leaseholder of that hotel.
Very
Who
good.
circulated, my lord, the post that the Bangladeshi, my lord, tourist will be, my lord, stopped from, my lord, booking.
Correct. So he made that post. Thereafter, who made those posts? And what is the other case in which he has been booked?
My lord, that has not been, my lord, here, my lord. I am not.
My lord, that is under section 505
This
and
is, my lord,
section
under
506.
505 and 506. my
So
lord.
506, is his post even falling within 506?
My lord, therein in the complaint, a line is there alleging that he received a phone call whereby he had been threatened. The complainant.
Give the number of that case.
My lord, I will provide the number.
Let me ascertain, my lord, whose number is this? my lord.
You also assert in this.
Lordship.
And what is the material against him? Section 5 of Registration of Foreigners Act is bailable,
Lordship.
right? And 14C is bailable or not?
Abatement.
Huh?
Abatement, my lord.
Abatement. Now,
Abatement. 14C is abatement. Abatement in respect of section 14, 14A or 14B.
So what is the evidence of 14C against him? You bring these materials tomorrow.
Lordship.
List, give your number, CRM.
CRM 985 and 984.
984.
CRM list along with CRM A 985 904.
984, my lord.
984, my lord.
984 is before, is no? List along with CRM A 984 of 2023 tomorrow. Case diary of CRM A 984 shall also be produced. Investigating officer shall be present. All right. Please clarify, because we find the more abusive post is against him.
Lordship.
Let us
Very
say he made a post saying that persons will not be admitted to our hotel. That at best is a discrimination, etc. It cannot be a crime, offense punishable in law.
Lordship, but this post are, my lord.
The other posts are more
Very
offensive. Next.
Grateful. Very good. Grateful.
22, one accommodation.
Why?
Just you see, they have handed over the scene.
One second. Who is for petitioner? Oh, this is Mr. Mojumdar.
Yes, my lord. My lord, all are magistrate travel offense. My lord,
Hmm.
principal accused, he is on bail. My lord, he has obtained 10 lakhs of rupees. My lord,
Mr.
by my
Mojumdar,
lord,
he wants one day. Tomorrow we are keeping it.
lordship.
Tomorrow. This may be violation of natural discrimination against etc. Challenge the license of the hotel, etc. Bombardment.
In this case, a complaint registered under section 448, 376, 506, and 109 of IPC Lordship. The
Okay.
15 lady is the
When 156(3) application was filed?
Lordship, that is on 22nd of August 2023.
Huh?
22nd of August 2023.
22nd of August.
And date of incident is 16th.
Is
of
it possible
July.
when the 156(3) application was filed? The FIR was registered on 22nd of August. The 156(3) may have been filed in July, on 10th of August or 7th of August. Yes, let us see the 164.
It is the matching lady and FIR
The submission we find very curious. Does marital status of a victim have anything to do with her allegation of rape? Married lady can as much be raped as an unmarried one, isn't it?
Yes. No such allegation of rape levied against him.
Then-
164, if you lordship consider that the present petitioner held the principal accused. Yes. Lordship.
He also
Surrender. The application for ancillary bail was filed on 2nd of August. The incident is of 2nd of August.
Yes.
Then there is no delay. Then the copy is received on 22nd of August. That is systemic delay. How this 156(3) application was accepted?
Isn't allowed for it.
Isn't the law under 156(3) requires an affidavit of the victim, of the petitioner, applicant? There's no affidavit.
Not verified.
Verified affidavit, Supreme Court of judgment, there must be an affidavit. All right, you surrender. We have called.
No such allegation of rape against.
Indian petitioner also entered into the house of the victim girl.
You assisted the rape.
Yes, sir. And he
That's
assisted.
the only allegation.
Everything is an allegation. Like even the allegation of rape is also not proved as of now. Yes.
Brother.
Brother.
How can I help my younger?
Why not? Why not? There is enmity between you and the other family. You surrender. Petition. We have a call.
No, there is a serious allegation against you. এই সময় 2 নম্বর আসামি প্রার্থীর 2 হাত জোর জবরদস্তি চাবি ধরিয়ে থাকে। What is this?
Please, sir, surrender. We will consider your regular bail not fit for ancillary bail. Why? Why? Then again, application for ancillary bail.
Yes.
Such efficiencies of our investigating agency. Even if it is rejected, be rest assured we do not know whether he will be apprehended or not. Petitioner contends that the allegation of rape contends there is enmity between them, the petitioner and the family of the victim. There is delay in lodging first information report. He prays for ancillary bail. We have learned a lawyer for the state opposes the bail prayer. We have considered the materials on record. Statement of the victim shows petitioner and his brother had come into the house. He held the hand of the victim while his brother committed rape, committed rape. Application under section 156 subsection 3 CRPC was promptly filed, and delay in the matter is due to systemic reasons. Under such circumstances and in view of the nature of offense, we are of the opinion this is not a fit case to grant ancillary.
There is no inquiry or investigation even after she visited Women Police Station. Thereafter she sent the matter to SP Kuchbihar. 156 has been.
You surrendered. You surrendered. Ask for regular bail with us. Next.
I'm grateful to your lordships.
Wife of the principal accused.
Is the wife of the principal accused. And what
Now,
is that?
principal accused is
To
again
clear the
having
evidence,
affair with another.
He took the 15 years old minor to the for an illegal termination.
Surrender. Petitioner submit. She is the wife of the principal accused. He has been falsely implicated. Learned lawyer for the state submit. Petitioner had assisted the had taken the minor for illegal abortion. We have considered the materials on record. Husband of the petitioner subjected the minor to penetrative sexual assault. Thereafter, petitioner and her husband. She alone took or husband?
No, she along with another 2 ladies. One of the lady has been arrested.
Thereafter, petitioner took the victim for illegal abortion. In view of the nature of the crime and involvement of the petitioner therein, we are not inclined to grant ancillary bail. Next.
25 and for the state of petitioner.
Yes.
But pertaining to a political rivalry, almost adopting a pick and choose policy, almost 16% have been carried in the FIR.
Yes, what is the involvement of these petitioners?
Here, my lord, 12 accused persons.
আমার ভাইকে আমাদের একজন
The alleged incident, my lord, allegation or post, my lord, panchayat election.
who is
Lordships, some of the petitioners are involved for 161 statement specifically. Allegation intention to capture the booth, your lordships, and fired and got bullet injury. Intention is clear. 307 is.
you surrender? 3 or 4 bullet injuries.
Yes, your lordships.
3 or 4 bullet injuries, not 1 bullet.
Intention is
Specific allegation.
Well, you are a part of a group.
Only
Part of a group.
who were present, my lord, who were particularly specifically
All of them are named.
named. But only a political vendetta and nothing else. You know, the subdivision of Calcutta will always become one of the epicenter of all political violence.
Hmm. They have not been named by the witnesses.
lordship.
Then
But some name is reflected in the 161 year lordship.
where is the
Lordship,
161?
one Munna Ali and Jairul Haq. Both had been to the booth and tried to capture the booth, and when he desist, they fired.
Munna Ali and my lord Jumikul is the petitioner number 1 and 2.
No.
Others names also.
Others are there.
Yes, Lafit, some 161 stated name, everyone stated ultimately they are the.
Further to it, my lord, all of the petitioner has been added.
The statements, the name of the witnesses, accused person. তখন আমিনুর মিয়া বলো
আমিনুর মিয়া,
নেই,
জিয়ারুল হক,
জিয়ারুল হক,
শাহানুর হোসেন,
সাহানুর হোসেন নেই,
আনোয়ার মিয়া,
আনোয়ার মিয়া,
মনোয়ার মিয়া,
হ্যাঁ
নূর কাসেম,
হ্যাঁ
বিপ্লব পাল,
নেই,
আজিজুল হক,
আজিজুল হক, হ্যাঁ,
তপন চক্রবর্তী,
তপন চক্রবর্তী,
মুন্না আলী,
হ্যাঁ
মুন্না,
মুন্না,
হাফিজার রহমান,
হ্যাঁ তারপরে
সহ আরো অনেকে। এছাড়া আচ্ছা অন্য কোনো স্টেটমেন্ট
না, আর অন্য স্টেটমেন্ট নেই। We are not finding Kudus Ali.
Lordship, some name is not there, but
So tell us which names are not there. Kudus Mia alias Ali is not there. Monirul Khondokar is not there. Liton Paul is not there. Anil Bormon alias Anil Kumar Bormon is not there. Latif Mia Abdul Latif is not there.
Return for them is revealed.
এইখানে আছে অন্য একটা এতে আছে বিরোধী আমিনুল হাফিজার এজাহার
You tell us which names are there. Which... All right, not today. Not today. Please go through them. Give a list which names are there and which names are not there.
Lordship, they can't.
And if all the names are there, indicate to us all the names.
Highly ordered.
Not today. At least two witnesses should say that these names are there.
But 380, my lord, 34 and 411 of the Indian Penal Code, my lord. Well, allegation is that some of the, my lord, miscreants, my lord, had stolen, my lord, some tea leaves, my lord, from the factory. 5 persons were arrested and they granted bail by the learned court below. My lord, from their statement, these prisoners are implicated. And the, my lord,
At first,
one of the
Stolen articles have been
recovered, my lord.
Lordship, when Raju Burman, the security guard of the factory, was apprehended, he disclosed the name of Anando and Govindo. Anando was apprehended and Anando was taken into custody PC. Anando brought the police to the house of the petition number 2 Ranjit Kaviraj, from where some articles were seized from his godown, and the statement of the wife of Ranjit Kaviraj is there, that fully knowing the fact that these are stolen. Ranjit Kaviraj and Govindo Das and Ananda Das, both of them were co-accused committing the offense. But Govindo absconded, Ananda was arrested along with some articles.
But Nipon Das is my brother. And from his house, my
11 lakhs 50,000.
We have considered the materials on record. Tea leaves,
11 lakh
part of the stolen articles, that is tea leaves, were recovered from the house of petitioner number 2. Materials also disclose the involvement of petitioner number 1 in the theft of tea leaves. Investigation is still in progress. Possibility of further recovery upon custodial.
quantity of seized articles
But 7,500 grams of.
it is stolen.
Kilograms.
Stolen.
Stolen. And
Now
from
recovered-
his
recovered-
daughter,
But 150,
more than
150
150, 100
Kilo.
kilo.
150 kilo.
8 packets.
No, the stolen articles, entire stolen articles.
Yes.
are
No, not entire stolen. Some
That is
sold.
what we are saying.
Yes.
Uh, investigation is still in progress. Custodial interrogation may lead to further recoveries.
But I will cooperate to the investigation.
Yes, in police custody.
Kindly consider, my lord.
Such
I'll cooperate.
circumstances. No,
But I-
sir.
Kindly keep the liberty,
No,
my lord.
sir.
Grateful then.
আগে মোকাই করে দিয়েছি দিয়ে চা প্যাকেট কিনলে দিয়েছে প্লাস কিনে ওখানে থাকারও ব্যবস্থা আছে
My lord, I am for the appellant. On the last occasion, my lord, there was a direction upon the parties to serve the report.
vehicle.
Yes, my lord.
Accused was acquitted, but vehicle was not returned. Against that, the lordship filed an appeal.
How can this application be maintainable? You should, where is the original order of acquittal?
Whether there was any confiscation?
Yes, Lordship, yes.
Confiscation হয়নি, give us the origin, where is the original order of acquittal? Where is the order of acquittal? Produce the order of acquittal. Madam, in that order, while acquitting, there is a consequential order of confiscating the vehicle.
Yes, ma'am.
Yes, that order has to be appealed.
Yes, my lord, and against that confiscation order, an application was.
You cannot file an application before the same court. The confiscation order needs to be appealed before the High Court.
My lord, for the confiscation order, my lord, I have preferred this appeal, my lord.
But only the
Have you,
rejection-
are you understanding or you are intentionally submitting something to avoid the issue?
No, my lord.
There is an initial order of acquittal disposing of the trial. The confiscation is a part of that order.
Yes,
Thereafter, the trial judge is functus officio and your application for return has no jurisdiction to entertain it. You are challenging that order.
yes,
And
my
so we have to dismiss this appeal saying that the judge was right. If you really want to give relief to your client, you have to challenge the original order in which the confiscation was awarded. And against that order, the appeal will lie. That the accused so and so confiscated. এই orderটা 12/7/2022. তারপরে তো
Lordship, in the order portion, the procedure for confiscation has been further elaborated.
Last line of that para, last line of that para.
all right, so we entertain this appeal on this point. Appeal is admitted. Issue notices. Lower court records call for. Let the matter appear for called for.
Next.
Let the matter be placed for hearing before the next circuit bench. That order has to be accepted. That order. That application, what you are.
There's a can file limitation act.
Limitation is condoned.
Can has to.
Yes, ma'am. Last occasion, it was already condoned, my lord.
Where is 12/7/2022? Where is the order dated 12/7? The certified copy of the order dated 12/7/2022. এটাই তো নয় বাবু। ওইটা case was initiated.
যেটা অর্ডার করেছি
হ্যাঁ, কেউ তো where is the order of acquittal?
My lord, in the last, that is page 9 number. After page 28, my lord, the order is annexed.
Correct, that order is not an order of acquittal.
judgment.
That is not an order of acquittal. When was the accused acquitted?
12/7/22. This is the date of
In terms
delivery
of page 8,
Confiscated.
the
12/7/22.
first para,
Hmm.
accused Shamir Sheikh.
ও তারপরে
not
আপনার
guilty to offense, and are acquitted.
ওটাই তো দিতে হবে। You need to confiscate the A. So we are admitting the appeal against 12/7/22 order. Order appeal against confiscation of the vehicle. Vide judgment and order dated 12/7/22. No, appeal is directed against so and so to the extent it confiscates the vehicle. Full stop. Appeal is admitted, issue usual notice. In view of the nature of the appeal, preparation of paper books are dispensed. Can condone হয়েছে কিনা দেখে নাও, যদি না হয় can delay has been condoned in the earlier order. All right. Then why the
We have received the service.
then affidavit in opposition?
Yes, my last.
So have you filed any affidavit?
Not yet received.
All right, ঠিক আছে। ছেড়ে দাও।
Condition হয়নি না? তাই তো বলছি আমি। 10 more has to be disposed of then.
ওটা আগে করে কর। Next.
Oh. 10 more to dispose of them. Okay, I am for the applicant. Not the application.
ডিফেক্টটা কি? Delay in preferring the appeal. Produce this condone, issue admitted, issue usual notices, call for records. Liberty to pray for suspension of sentence upon notice to the state. And the victim. Next.
Lordship, I have been appointed from the Legal Service Committee. Lordship, the section 5 is equal to 5, and we have applied for the to the correctional office for the authentication of this, but not yet received.
Please before the next circuit bench.
Lordship.
Learned counsel for the appellant seeks time to file application for condonation of widow. Steps be placed before the next circuit bench. Steps be taken in the meantime. Next.
Lordship, item 30 also same.
Same order.
31.
In this matter, Mr. Vinod Agarwal is the special PP for the National Investigating Agency, Lord. Vinod, I am praying for next circuit, Lord.
Your Lordship, I am for appellant.
What do you say?
Sorry, Your Lordship.
What do you say?
Sir, admission of hearings are today, the date is fixed.
Today hearing and we will pass the order today.
Lord, CD has not arrived. Lord, IO was contacted. Lord, some time is required to for the CD to come down from Delhi, my Lord. My Lord, keeps it the next circuit, my Lord. CD will arrive in the meantime.
All right, appeal is admitted. Full stop. Matter shall be in view of the nature of appeal. Lower court record, neither lower court records are not called for. Matter shall be heard on merit. In view of the nature of appeal, matter may be heard on merits without calling for the lower court records. Full stop. Opposition be filed to the within 4 weeks. Let the matter be let the matter appear before the next circuit bench.
Great for Your Lordship.
Under the heading bail application.
Date in connection with that.
This is a bail application, simple.
Grateful.
Or under the heading appeal direct against rejection of both.
This I am for that. With the admission of appeal, 8 years punishment, and that's 300.
Appeal admitted, issue usual notices, call for suspension of sentence upon notice. Next.
Look, 33 and 34. Lordship, this is that matter where the revision was filed by Mr. Mukherjee, and Mr. Mukherjee is online, Lordship.
Well, there are two applications basically, one for cancellation of the bail and the other is for transfer.
Mr. Mukherjee, this application needs to be assigned to us.
I get your lordship. I was thinking about that in view of section 9, chapter 298. I was thinking in those terms. Well,
No, we are already passed an order. State shall take necessary steps for assignment of the revision petition.
okay, my lord. Now then we'll take steps, my lord. Then keeps it at
Please,
that.
please take.
Yes.
We keep it
I'll
up.
take steps, my lord. I'll take
Next
steps.
circuit.
Next circuit, but it can't be done, I think.
We have already,
What is the procedure, my lord? I'm not aware of the procedure, my lord.
What, Mr.
The
Mukherjee?
procedure of said this will go to Calcutta principal bench for the Chief Justice to assign to your lordships.
Yes, the Honorable the Chief Justice has to assign this matter to be placed before the division bench.
Oh, right. I'm grateful. my lord.
Otherwise, we cannot take up the revision petition, right?
Okay, my
Mr. Mukherjee seeks time to take steps for assignment of the revision petition. Full stop. Let the matter be placed before the next circuit bench.
Great. But both the matters.
Let the matter, because this matter is, we cannot take cognizance of this matter.
Right. I'm grateful, man. I'm grateful.
I am for the opposite.
রোশন, তুমি করে নাও এটা।
Next division bench.
দিয়ে দিচ্ছিলাম, দিয়ে দিচ্ছি।
You get it assigned and then.
Yes, Lordship, already it has been filed there.
Nobody appears, please before the next circuit bench. Anyone appearing in 36? Next circuit bench.
লাস্ট ছিল এটা করে
37, anyone is there?
Yes, your lordship.
Ah.
In virtually, your lordship.
Yes,
Learned advocate Arnab Shah.
yes, tell us.
Yes, sir, I'm for the application.
Right.
In the by the last order on 22nd on 2023, Lordship, the applicant was directed to serve a copy upon the notice upon the respondent, Lordship.
Yes.
That in compliance with the direction, copy has been served, but that has not yet been
Service is not complete. Let this matter appear before the next circuit bench. Other matters will take up after 2 minutes.
Next circuit hoche.
Yes. Okay.
the stay application be carried out in the course of the week. Be carried out by tomorrow
My lord, can we grant a little more time?
in the course of the week.
Lordship, grateful, Lordship.
So, let this matter appear before the next.
Grateful.
Canon 3 and 4 is posted.
Grateful.
Next. 39.
My lord, in this, my lord, this matter was filed before the principal bench. Thereafter, it was transferred to circuit bench, my lord. On several occasions, my lord, several occasions, we didn't have any brief to represent the court, the appellants, my lord, since it was filed before the principal bench. On the last occasion, my lord, or the second last occasion, Mr. Bikram Aditya Ghosh appeared for the state, but he has retired from the panel, my lord. So we need some accommodation.
What accommodation? Have you seen the order?
My lord, yes, my lord, I have gone through the orders.
Then it's a decision to be taken.
Yes, my
No
lord.
final order was passed, and
My lord,
then you
only
take a
just
decision.
last chance.
No, last.
My lord.
Writ petitioner, appellate, writ petitioner respondent had approached this court complaining that family pension, contending she is entitled to family pension.
My lord.
Contending she is the dependent of a deceased employee and was entitled to family pension.
My lord, the state is challenging the order of the single judge, my lord, wherein the respondent petitioner was given liberty to get the family pension, my lord. But my lord, as per GO number
right
2299, my lord, dated 12th of December 1972, my lord, the grounds of my page 3. Memo of appeal, my lord, page 3, my lord. Family pension can be allowed to the deceased employee, family of the deceased employee for only 5 years at the rate of 375 per month. But in this case, my lord, the petitioner's husband died
Where is
in service after 2, my lord, page 3, the grounds.
Page 3 of the grounds.
Page 3 of the memo of appeal, my lord.
Memo of appeal. Was this notification placed before the learned single judge? Memo.
My lord,
page 3. Adding law and considering.
ground number 3, my lord.
But she is entitled to family pension from the day on which the GO comes into force.
Yes, my lord. But in this case, my lord, the husband of the petitioner died. He has completed service for only 2 years and 10 months. Now, my lord, if my lord come to ground 5, my lord.
Let us see the ground number 3. What is as per prevalent policy? Family pension allowed for 5 years, subject to completion of the deceased.
Deceased died on 15th of June 1970, my lord.
Right.
Prior to this GO, my lord.
Right.
Whereas the learned single
Now-
honorable
Please see Roman 4, Geo 539, 111, 2010. Why it is not applicable? So you considered these issues, pass a reasoned order. That is what the judge has wanted.
My lord, but there is one difficulty. The honorable single judge asked the state to compute the pension amount from the date of death of the husband of the petitioner. That is from 15th of June 1970.
Correct that for that, if she is entitled from 1981, it will be computed from 1981.
But the other portion of the order, my lord, that is
What portion of the order?
troubling us, my lord.
We don't understand what is troubling you. First, is she entitled? Yes or no? If she is entitled, take a decision. If she is not entitled, then the other portion of the order does not come into being. See the order.
Yes, my lord.
What does the order say? First,
Compute the-
consider and take a decision whether pension can be granted or not.
Yes, my lord.
You are saying pension cannot be granted at all. If pension cannot be granted at all, the second portion of the order does not come into being.
No, my lord. The pension can
Be granted
Granted,
according to you.
Yes, my lord.
Now, if pension can be granted according to you,
Now the second portion comes to compute it from 1970.
why
That
it
is the
cannot be
difficulty, madam.
computed? In the event it is found they are entitled to family pension, compute the amount of family pension and take steps for disbursement, including the arrears from 15/7/2017.
That is the portion which is troubling us, my lord. We cannot count it from.
Why?
Because
Why it cannot be counted?
Because the geo came in the year 1972, my lord.
The geo may come in 1972. If it is geo comes in 1972, if the person is entitled to pension, he will get the pension.
But the calculation will be from 1981, my lord.
Well, how? Is there anything specific in that geo that it will be calculated from 1981?
My lord, the second geo dated geo number 539 AC dated 1st of November 2010.
Right. Where is that geo?
That's why, my lord, I need some time, my lord. Kindly take it up any day this week, my lord. Kindly, my lord, any day this week, my lord, I will apprise, my lord, because I have to go through all the papers, my lord.
We do not find any illegality in this one. It is 2010 policy documents.
সূত্র শুনতে পেনশন পাচ্ছে না
2010-এর পেনশন পলিসি থেকে এন্টাইটেলমেন্ট আসছে
38 হয়ে আছে 38
Hmm.
If
Reject. The financial benefits may be given with effect from 15/6/1990 or from the date of application, whichever is. হ্যাঁ 1990 ওই জন্য 70 থেকে তো পারে
এক্সক্লুড করে দিচ্ছে যেটা আছে যদি এক বছর মানে
না 1 বছর তো হয়েছে
1 বছর হয়েছে
at least 1 year. He's got 1 year qualifying service.
My lord?
1 year service the employee had, na?
Yes, my lord.
This is the employee, he was in service for 3 years.
2 years.
He was in service from 1st of August 1967 to 15th of June 1970.
2 years, 10 months.
2 years, 10 months. So he qualifies in category F, 3F of the scheme.
না এটা দিবে না বলছে এটা তো তুমি বলছো এটা পাবে না নাকি
না পাবে। It has been observed that the following were not covered
under this.
of the under the so এটা ছিল না বলে paragraph 4 entitles them to pension. But madam,
Paragraph 4 gives the extension of pensionary benefits to the employees.
Madam,
Yes, Your Lord.
you are in agreement with that. But come to the last 2 lines of paragraph 4.
Paragraph of my lord.
Paragraph 4. The final benefit may be given with effect from 15/6/1990 or from the date of application of pension, whichever is later. Now you understand? If that is so, the order of the learned single judge entitling you to pension from the date of death of your husband is not in consonance with the terms of the scheme.
Lordship, kindly see the order of the learned single judge.
Yeah, that's
Where,
me.
my lord, these are the
Please tell us whether you are entitled to pension from the death of your husband or from the cutoff date as noted in paragraph 4.
I'll have to take instruction.
What instructions will you take?
One thing, my lord, I want to submit to your lordship before your lordship is this. Lordship, kindly go through the order, my lord.
We have gone through the order. We are posing a question to you with regard to the order.
In the order, my lord, there is no mandatory direction.
Who said?
My lord,
Who said? So we clarify that.
if it is
Please,
from-
madam, listen to us. We clarify that if it is granted, it should be granted in terms of paragraph 4 of the scheme. and the interest will be payable from the date of such entitlement at 9% till the date of actual payment. Correct? Happy? Sure. Good stuff. No, lekho. Appellant state has assailed the order passed by the assailed the impugned order passed by the learned single judge primarily on the ground that even if the writ petitioner is entitled to family pension as per notification as per GO number 539 SC bracket P and B dated 1/11/2010, comma, her entitlement could not have been from the date of June is the death of your husband, na?
Yes.
From the date of death of her husband, that is 15th June 1970. Learned counsel for the appellant state refers to paragraph 4 of the said notification, which entitles the writ petitioner which restricts the financial benefit, which states the financial benefit shall be extended to the widows of the deceased employee with effect from 15/6/1990 or from the date of the application for pension, whichever is later. Full stop. Learned counsel for the writ petitioner contends her client is the widow of a deceased employee who had rendered more than 1 year of qualifying service. Who was employed? Madam, who was employed?
Primary school, Dinata Division.
Date.
On lordship.
Yes, you told us. Date of appointment. Date of joining.
Who joined as a head teacher of Indreshwar Primary School, Mathalhat, Dinhata, Kuch Bihar, on 1/8/1967 and died in harness on 15/6/1970. Hence, he was entitled to the benefit. Hence, she was entitled to the benefit of family pension as per the notification dated 1st November 2010. Good stuff. We have perused the order under appeal by the order impugned the learned single judge had directed Principal Primary Education Department of Government of West Bengal to consider the issue of grant of family pension to the petition, to the writ petitioner, that is being the widow of the deceased employee. Would stop. In the subsequent, thereafter, the learned single judge directed. Now, thereafter, it was further directed. In the event petitioner is entitled to family pension, the Principal Secretary shall compute the amount of family pension payable and take steps for disbursal of the same, including arrears, from 15th June 1970. Full stop. The petitioner, being the widow of the deceased employee, has founded her claim on the notification bearing number 539 so and so dated 1st November 2010. Full stop. Paragraph 4 of the said notification restricts the financial benefit given to the widow of the deceased employee with effect from 15/6/1990 or from the date of the application for pension, whichever is earlier. Full stop. In such view of the matter, the direction of the learned single judge that the petition, that the family pension is awarded to the writ petitioner must be computed along with arrears from the date of death of her husband, that is 15th June 1970, is not in consonance with the aforesaid notification. Accordingly, we modify the aforesaid direction and direct the Principal Secretary and direct, in the event petitioner is entitled to family pension, the Principal Secretary shall compute the amount of pension payable to her in terms of paragraph 4 of the said notification, that is from the date 75 years. Paragraph 4 of the said notification.
I have a report, my lord, wherein it has been stated that with effect from 1st of April 1981, she is already enjoying the family pension. She is already enjoying the family pension.
You pass that, you take, you place that report, then what is the use? The appeal can be withdrawn on that premise. If your client is already enjoying family pension, then there is no scope for the appeal. What is the use of the appeal?
With effect from.
So you
Lord, I have only one copy.
Sir, let us do like this. Let us dispose of the appeal. You take a decision in terms of this order.
My
lord. But paragraph 4 of the said notification. It is further directed decision with regard to entitlement of family pension shall be taken within 3 weeks from the date of communication of the by the Principal Secretary concerned, within 3 weeks of the communication of the order. If the petitioner is found entitled to family pension, the amount payable to her and all area payable to her, the secretary, principal secretary shall compute the arrears within 2 weeks thereof, arrears in terms of paragraph 4 of the notification within 2 weeks. Paragraph 4 of the said notification, and the pension along with the arrears shall be released within 2 weeks thereof. Within 2 weeks thereof, full stop. In the event, now petitioner shall be entitled to payment of interest on the amount on the arrears as calculated at the rate of 9% per annum till actual payment, full stop. Other portions of the order, impugned order shall remain unaltered. Yes, disposed. Next. রাম শ্যাম জ্যোতি মধু বিভাস নিয়ে গেছে সুভাষের কাছে আছে। Yes, next matter.
Item number 40 and 41. Lordship, item number 40 and 41, I am paying for next circuit, Lordship.
Next circle on the prayer of the appellant.
Grateful, Lordship.
Next. Forty-two. You want business করে দেয় কিছু বিজনেস করতেও চাই না না আমাদের ফাইল কাউন্টার কিছু by order dated 4/7/2022, a coordinate bench of this court noted that the appellants were unrepresented and it was unrepresented. It was and the matter was peremptorily listed on 7 July 2022. It was observed if the appellants are not represented on the adjourned day, the appeal shall be dismissed. Thereafter, the appeal has come up for hearing on a number of occasions, but the appellant has remained unrepresented. It appears that the appellant is not vigilant to prosecute the appeal. Accordingly, the appeal is dismissed for default. Yes, tax. What do you say?
Well, there was a direction in earlier, but when the writ was filed, at that time.
Is this surviving?
No, no. At that time, West Bengal Taxation Tribunal was not there. Now West Bengal
So
Taxation
let the matter
Tribunal,
be.
so let the matter be.
Place, party will be at liberty to approach
Yes,
the.
yes, ma'am.
But limitation, etc.
No, because it was not functioning. So that's why he will condone the.
There is provision for condonation of delay.
Yes.
All right. Appellant submit that. Oh, nobody is appearing. So we cannot pass that order. We dismiss for default. Who is for appearing? Give a notice. Huh? Nobody appears for the appellant. Mr. Agarwal. Mr. Agarwal with Mr. Hirok Burman appears on behalf of the state. Mr. Agarwal submits that the West Bengal Taxation Tribunal, but it's a repetition has been dismissed now. What?
No, at the relevant time, the writ petition was admitted because the tribunal was not functioning.
No, you see the impugned order. Impugned order says the jurisdiction of High Court and so and so suppressing anything.
There are cases that without submitting notice, the attachment was done. We have submitted all documents showing that.
Notice was given.
So there is.
So we did not issue pass any order on this premise. Whether they can go to tribunal or not, because the dismissal is not on the ground that the admission. If there was an appeal, we would have, if they had admitted the writ petition, here the writ petition was not admitted on merits because they had come with unclean hands, they suppressed the fact that there was notice, right? So we did not go into that, Mr. Agarwal. So and so, we'll stop. Fresh notice be issued upon the respondent is directed to issue notice upon the appellant as well as his learned advocate, intimating in the event the appellant is unrepresented on the adjourned day, the appeal shall be dismissed. Affidavit of service be filed on the adjourned date. Matter will appear on Thursday. Give notice on the appellant. You can serve them by Thursday, right? So you give notice to the advocate on record of the appellant, right? In the event the appellant is not represented, the appeal shall be dismissed. Thursday.
Great.
Next. Superintendent of Police. Bolu. Why? So the state council retired doesn't mean not this week. Every week you will retire one council and appoint another council, no ground. Oh, you make your allocation overnight. We are not bothered about your allocations too. Inspector shall visit. See, there is an interim, this order has already become infructuous. Have you seen the order? Will visit the site in question within 24 hours from date of communication and assess the number of policemen required for the purpose of vehicle construction of road.
As you lordship.
Deposit costs for police posting. Achha. If they deposit cost, let them, I don't know. Next circuit, nothing is there. On the prayer of the appellant, কিছু নেই। একদম ফাঁকা। ওই cosmetic মারিয়া লাগে।
The Lordship, I appear for the respondent number 4 to 7.
Yes.
My Lord, they are aggrieved by the charge sheet. They have not filed the Naraji petition, which was recorded by the learned single judge, as well as, my Lord, by the division bench itself.
Correct.
They have their statutory remedy, my Lord, by jumping that jumping forum they are using, my Lord. They are simply doing the shopping, forum shopping, your Lordship.
Lordship,
Yes.
it's not only a question of charge sheet.
Then it is a question
It's
of what?
entire question of investigation. The gist of the, and on the last occasion, your lordship was pleased to direct the investigating agency to seize the mobile phone the day on which the incident occurred.
Right.
After a long lapse of 3.5 years, the investigating officer has seized the mobile phone. Now, the short, brief point is
Now, investigating officer has seized the mobile phone.
mobile phone only.
Sir, please give a report with regard to steps taken in further investigation. Yes, what progress have you made?
But on pursuant to the direction of this honorable court on the last date.
Yes.
But the mobile phone of the alleged victim has been seized and some documents pertaining to the agreement.
All right, you have been sent to cyber forensics.
Yes, yes.
All right.
And some documents have
All right, report is placed on record pursuant to order dated 29/11/2023, passed by a coordinate bench of this court. Mobile phone of the deceased has been seized. Would stop. The mobile phone has been sent to Cyber Forensic and Digital Evidence Examiners Laboratory, CID, Kolkata. Due to technical fault, the exhibit was returned. When will you send it? Due to technical return, the exhibit was returned, and we are informed at the bar that the item has again been resent for forensic evaluation. Other documents have also been seized.
Lordship, may I submit one thing?
The screenshot of the suicide note of the deceased on his Facebook account has been produced before the investigating agency. Further investigation is in yes, tell us.
Lordship, the property on which this dispute is going on, that's a property of judicial department, and that has been acquired in the year 1975, and acquisition was done. Only the documents of the accused persons were seized, but this acquisition proceeding, gazette notification has not been has not been seized,
What
which
is-
will reveal.
Reveal.
That is not the sub and
Please,
substance of the
sir,
matter.
1 second.
My lord, my lord.
That will reveal the manipulation motto and thereafter the incident.
Can't understand. What it will really
Lordship,
reveal manipulation.
Lordship, the property which has been acquisition, these private persons have prepared some documents from the office of the BL and LRO, taking it as written. And after that, this process is going on for eviction.
What that has got to do with the suicide?
Suicide, the only motto to evict this person by procuring these manipulated documents, and only the deeds and
All right, whatever documents you have, produce them before the investigation.
Lordship, it is instructed to me that my client had been to the office of the.
They are directing you to produce them before the investigating officer. Whatever documents.
The prince of the said no, that the receipt all statements that are has been published before the investigation.
By the de facto complainant, full stop. A learned counsel for the appellant de facto complainant submit. There are other documents which will establish the motive of the crime. He is at liberty to produce. He is at liberty to produce the relevant documents before the investigating agency, and in the event the documents are produced, the investigating agency shall take into consideration these documents for further investigation. In the course of further investigation, report with regard to further investigation be filed on the adjourned date. Matter will appear 2 months hence.
Deeply obliged.
Copy of the report will be. Copy of the report.
Were you?
I'm for the response.
Zero. Nothing. Not necessary. Once the charge sheet is filed, relevant copies will be given to you.
The charge sheet has been filed long back. They have not preferred the Naraji petition till date.
A supplementary charge sheet will be filed. Don't worry.
Deeply obliged, Your Lordship.
Not it either. Next. Yes, Mr. Balmon.
Here is our referee service here. Athlete is the BA school.
Very good.
We have served on all the.
What is the order impeding? Where is the order impeding?
There is a limitation. We have filed an application.
Respondent? Huh? All every service filed, nobody.
I am for the school service commission.
Trained with him.
Lordship.
Read petitioner. Has he been served?
Lordship.
Then nobody appears. Every service file, nobody appears for the read petitioner respondent. Fresh notice be issued upon the learned advocate who represented the read petitioner respondent before the learned single judge. Affidavit of service be filed. Matter will appear before the next circuit bench. Next.
My lord, in item number 47, there was a direction passed by a coordinate bench of this court to correct the defects in the appeal within a specified time. And I'm seeking an extension of the same time.
You're not prosecuting the appeal with
Well, actual
diligence.
the defect is that to the number of the
It's a minor, that's why we are saying, if it was something, service, etc., it's a minor correction.
Yes, my lord.
All right. Appellant shall carry out the shall cure the defects positively within 2 weeks from date, failing which the appeal shall stand dismissed. Huh? Dismissed. This order is peremptory and final. A last chance is given to the appellant to cure defects. Defects are positively cured, failing which the order is peremptory and final. If the direction is there, it shall stand dismissed. Next.
There was direction to serve copy. I have attempted, but the endorsement says addressee cannot be located on hold.
Every service filed, service is not complete. Fresh service be effected on the respondents. Evidence of service be filed within 4 weeks. Every service be filed. Yes, next matter.
Not in 49, I appear for the appellant. Not as directed by your lordship in lordship's last order that served upon the respondents.
I'm appealing for the respondent petition.
Yes. This appeal hangs on a very short compass. The impugned order states that a deposit in the name of the petitioner, writ petitioner, has to be made by us, the school authorities, as a condition for us to give our affidavit in opposition. That is, my lord, what we are seeking setting aside.
No, Lordship,
My lord, in doing so, my lord, the learned single judge perhaps lost sight of the fact that the pension releasing authority is the DI of schools, my lord. The school authorities do not have anything with the pension, to do with the pension. But that condition was imposed upon us.
No, what he is saying is not correct, Lordship. He has not filed any stay application. I'm just pointing out this. The DI has given instructions to the teacher in charge to revise the basic pay of the petitioner. Why he is not following that? For this purpose, the Honorable Single Judge was pleased to impose a cost.
My lord, the crux of the matter was
state government had issued a notification for revision of the pensionary benefits. Thereafter, DI has by its memo dated 22nd May 2020, he has instructed the teacher in charge of Nilani Vidya to revise the basic pay. Why he is not following that? And he's
but
saying
my lord,
that
afterwards, the DI of schools through an independent inquiry found out that a charge sheet is pending against the petitioner. That is, my lord, the crux.
Lordship, I have been acquitted in that matter.
He has been acquitted.
Yes, he has been acquitted. But my lord, this condition precedent upon us.
Absolutely perfect.
But
absolutely perfect. Don't contest, don't file affidavit. Let the writ petition be disposed of.
My lord,
release the pension if you want.
My lord, the DI of schools is an independent body to release
we are
the
not
pension.
Concerned about DI of schools.
Yes, my lord.
Take steps to revise his pension order,
my lord,
and instruct the DI of schools to.
But my lord, that communication has to first come to us from the DI.
The DI
that is there.
But after this communication,
from the DI
this communication that the petitioner is placing before your lordships is a prior communication, my lord. But afterwards, the DI through an independent inquiry found out that the charge sheet is pending.
That charge sheet has ended in an order of acquittal.
Yes, my lord. But we are also awaiting instructions from the DI.
All right, we'll dismiss the appeal.
My lord.
The learned lawyer for the appellant has assailed the impugned order passed by the learned single judge, directing the appellants, that is the teacher in charge, that is the president of the managing committee, and the headmistress of Nolini Vidyamandir to deposit a bank draft amounting to rupees 6 lakhs. As a condition precedent for filing affidavit in opposition to the writ petition. Learned counsel appearing for the appellant submit the authority to submit the dispute arose relating to revision of pension, right?
Division of pension.
Revision of pension of the writ petitioner employee by though the DI of schools had vide memo dated 22/5/2020 directed revision of pension, it was subsequently detected that the petitioner was involved in a criminal case. As a result, his pension could not be revised in face of fresh direction by the concerned by the authority concerned, that is DI or Director of Pension and
Inspector of schools.
by DI of Schools, Secondary Education, Shiliguri. Stop. Learned counsel for the writ petitioner respondent contends that the criminal case has ended in an order of acquittal. We have considered the rival submissions at the bar. Stop. By the bar. Learned single judge took note of the fact that the criminal case referred to by the appellants in the course of arguments had ended in an acquittal. Had ended in an acquittal, and no appeal ended in an acquittal, though an application for special leave had been prepared. The appellants were unable to satisfy the judge, the learned judge, unable to place on record whether the appeal had been admitted or not. Full stop. The aforesaid state of affairs show the appellants and other respondent authorities aforesaid state of affairs clearly show that clearly show the appellants as well as other respondent appellants were indifferent and has failed to take steps in the matter. Be that as it may, in the matter of revising the pension of the writ petition. Be that as it may, the learned single judge gave an opportunity to the respondents, to the appellants, subject to their depositing is why 6 lakhs? That is
That was the. That come from the petitioner that amount is pending.
that
amount has been misplaced or siphoned by the petitioner. That is 6 lakhs.
The criminal case may not
Oh.
concerns an amount of 6
Oh.
lakhs that was placed by the
Oh.
petitioner.
Be that as it may, the learned single judge to contest the case by filing affidavits upon securing the sum payable to the petitioner through revision of his pension, sum payable to the petitioner as pension, which had been withheld due to the aforesaid criminal case. Would stop. Depositing. We are line to now, after securing the amount payable to the petitioner as outstanding pension, that is this that is a sum of rupees 6 lakhs. Full stop. Order passed by the learned single judge is a discretionary one, is an equitable one, and cannot be said to be unduly harsh or unjust. Hence, we do not wish to interfere with the order in the intra-court appeal. Resolve this issue. They can take under the law.
As soon as possible.
Even if there's an acquittal, you cannot stop the pension. At best, you can take an undertaking from him. In the event of reversal, it shall be adjusted or whatever.
Yes. As soon as possible.
We could have disposed of this matter with these directions if you want, but your appeal is very limited on that issue. Other matters too. Next matter, who is there? Vikramaditya Ghosh, Deputy Commissioner. Mr. Agarwal is there. This is with regard to sales tax, perhaps. Or it will come at 2 p.m. Mr. Mojumdar, which is your matter? 52, all right, will come after.
Item number 50.
I think you are saying. I think you are saying. Where is Mr. Shaha? Mr. Shaha is there. I think somebody appears. Next circuit bench. Next.
One. 51, my lord, I'm for appealing. Now, there is an injunction. Order of injunction.
What is your revenue to service? What is the interim order?
The interim order, my lord, restraining the respondents, my lord, therein from changing the nature and character of the suit property and transferring and or parting to with the possession of the suit property.
Take the appeal. In spite of service, nobody appears for the no, abroad service file. Nobody appears for the respondents. Interim order granted earlier shall continue.
Subsequently, it was extended.
Yes, my lord. My lord, the external, my lord, 31st of August 2023.
The suit before the trial court has been stayed.
Actually, my lord, before the trial court, they are appeared.
Then
they are appeared and they filed, my lord,
Now, what is the status of that suit?
suit for partition, my lord. Partition suit, and it was the injunction was rejected, accused by the learned court below, and we have filed the appeal before the district judge, my lord. But though the suit value is higher, for that reason we are filed this appeal before this honorable court. The receiver said that the receiver has no recognized jurisdiction for the appeal.
but you communicated, you did not communicate this order within 15 days.
Malad, first order.
Hmm.
Malad, there is a direction. We are communicated the order, but we are not filed the affidavit within affidavit.
Then 15/7, 13/7, the order was passed.
13/7 order is passed, Malad. We
It
are
has been
just
extended till in November. And you have communicated this order on 18th of November.
no, Malad. We
Yes.
are communicated this order on 1st of September, but we are not filed with affidavit.
1st of September.
Yes, Malad.
Please see your postal receipts. Please see that.
No, Malad, it was sent, Malad.
Hmm.
This application for extension of application is sent.
Then where is the communication of the order? Where is the order communicating this order?
Malad, we have served, Malad, but.
Where is it?
Service is not ready, Malad.
What if your affidavit of service does
No,
not say
Malad,
that
it is
at
the
all?
affidavit service that we are filed this extension of.
So this order has not been communicated to
No,
them.
Malad, we have communicated, Malad. I have
Where?
a copy of, Malad, I have copy of this receipt, Malad.
So that is not a part of your affidavit of service. You were directed to communicate
No,
this
Malad,
order
we have-
and file affidavit of service. See page 2, second paragraph of the order.
No, Malad, we have just not prepared, Malad.
Dispose of করে trial court-এ পাঠিয়ে দেওয়া উচিত, না?
Not kindly make it only note to them, Malad. We have filed this affidavit service.
Who is the lawyer representing the respondent, parties
No one
in the trial
appeared.
court? In the trial court, nobody has appeared.
In the trial court, one
Anyone has
advocate
entered
has appeared.
appearance.
Here, nobody appeared.
Anyone entered appearance in the trial court?
Yes, Malad. No. Who is the advocate? They are appeared, Malad.
Please give a notice to them. Affidavit service file. You also bring on record this communication of this order to the respondents.
Do you understand?
There
As
is a
per
direction. Have you seen paragraph 2?
Actually, Malad, we have served the copy, but affidavit service not ready, Malad.
You have received.
They have received, Malad.
Then
But
how
first
can you show us?
Let us
How
know.
can you show us?
kindly make it not.
Not to the-
Not to Malad. It's,
এগুলো ডিসপ্লে অফ করে শেষ করে দেবে কিছু নেই ঠিক আছে নেচার এন্ড ক্যারেক্টার চেঞ্জ করবে না
Actually, Malad, in the word,
করে দেবে করে দেবে ওটা এসে শেষ করে দেবে ডিসপোজ অফ করে দেবে বুঝলে নেচার এন্ড ক্যারেক্টার পার্টিস ইনজাংশন অ্যাপ্লিকেশন অ্যাপিয়ার করে অ্যাডিং টাইম অর্ডার এগেইনস্ট নেই যা আছে থাকে পার্টিশন নেক্সট
This is mine.
52
Yes, this is mine.
yes
Whatsoever, my lord. The tribunal passed and the learned tribunal passed the order, and my lord, here it is indicated that the chairman railway board to verify and consider, and thereafter, my lord, to release the pensionary benefit as well as the consumer benefit. What's that mean? The order was passed on, my lord, 9th
page
page, my lord, the last page, my lord, certified copy, my lord, page 240 after. Kindly see, my lord, in the order, page 3, my lord, paragraph 3.
in case it is established
The pension payment order was issued in favor of the petitioner, my lord, here, my lord, in grade 1 in the year 2014. But subsequently, the pensionary benefit as well consequence benefit not released till date, my lord. But kindly see, my lord, page 35 for a moment, pension
No.
payment order.
your order you have challenged. Which order you have challenged?
Plus tribunal order, my lord.
The 39/2019 order.
Yes, yes.
So there it was directed that the decision will be taken
Yes.
whether you are superannuated as ECM group 1 or group 2. If group 2, then
My lord, the chairman board did not consider, the railway chairman did not consider. What's happened, my lord? The Kathiar Johnson, my lord, rejected my claim that in the rejection order, inadvertently it is mentioned in the pension payment order. From 2014 to 2019, they did not given any notice, even this is inadvertently. Kindly see page 240. But there is a direction the chairman, railway board, but the order was by the Katia Johnson, the divisional manager, finance manager. Inadvertently, it is not inadvertently. The petitioner, the husband of the petitioner worked in joined in the railway 1950. Subsequently, 1961 he promoted grade 2, and 61 he was charged the grade 1. Grade 1 ESA grade 1. Electrical signal maintenance. And the electrical signal maintenance is grade 1. He performed his duty signal and telecommunication. Two wings. And in the state order, there is no reason, there is no specific reason. After retirement, thereafter several implementations was made. Thereafter 2014, he has promoted grade 1 from grade 2. It is indicated in the pension payment order itself.
After death of employee, you were promoted. When employee died? 90. So you cannot be promoted in 2014.
Not
Then-
promoted by I have charged grade 1.
That is what we are saying. Till 2014, you were treated as grade 2. Then in 2014, there was a revision. And in revision, you were treated as ESM grade 1. Oops. That is, right. Wait. So what is Yes, Mr. What do you say? There is a revised pension order that has not been set aside.
Lordship, the Honorable Tribunal directed us to find out whether he was grade 1 or grade 5. But the original service holder retired in 87, died in 1990. He received pension for up to 1990. He did not say anything that either he was grade 1 or grade 2. His wife comes up and says, no, he was grade 1. My lord comes to page number 240, subject to correction by your lordship. It is the memo dated 21/11/2019, after the order of the Central Administrative Tribunal. 240, my lord, of my paper, annexure 9, P9.
Oh, the order has been complied with.
Lordship, we have fixed him as grade 2.
So you have to challenge this order.
Let him challenge the.
You have challenged, the order has already been given effect to. The order that is your 29/8/2019, reverting the matter to be decided by the respondent number 1 Chairman Railway Board has already been given effect to. And they have fixed you at
Grade 2, my lord.
grade 2. Now, if you are aggrieved by that order, you have to take it out before. So that's a contempt application. 21/11/2019 is the order. When did you file the writ petition?
24 December 2019.
So after this order, can this order be challenged? Can you challenge the order of 21/11/2019 in this writ petition? Then
Suppressing the all fact. Suppressing the all fact, MA has been allowed.
so that MA has to be challenged. That MA has to be. Please, you are in this writ petition, what have you challenged? An order which purportedly has been given effect to. According to you, it has not been given effect to as per the order of the tribunal. For that, your grievance lay elsewhere. The writ petition, after the order having been given effect to, and without challenging this consequential order before the tribunal, is completely misconceived. Take down. Petitioner.
Page number.
Page number.
Order. One second, if you rely on an order, be kind enough to place that order instead of lecturing. That the coordinated bench presided by Justice Datta indicated whether the copy was served upon you so that to test the period of limitation to go against that MA. Nothing else. If you have chosen not to file anything against the MA order after it was disclosed on 10/1/2020, who can be blamed? Who can be blamed? Tell us. Correct. When it was divulged, it was incumbent on you either to assail this before this court or before the tribunal. You chose not to do either. And after 3 years, nothing survives. All right, that direction will take care. You understood. We will understand. There is nothing. Order dated. By order dated 3rd, 29th. Let us dictate our order. Thereafter, if there is any mistake, indicate to us. By order dated 3rd September 2019, the Central Administrative Tribunal had directed the respondent number 1, Chairman, Railway Board, to consider whether the deceased employee, bracketed husband of the appellant, had superannuated as ESM Group 1 or ESM Group 2. The imbroglio, next paragraph, arose in view of the fact, though the appellant had superannuated in 1987 as ESM Group 2 and had earned his pension in such capacity till 1990, a revised pension PPO dated 21/1/2014 had revised his status as ESM Group 1. Full stop. During the hearing before the tribunal, the service records of the the order remained, the revised pension order remained unimplemented. As a result, the writ petitioner approached the tribunal. During the hearing of the application before the tribunal, the respondents the parties took rival stances. The parties took contradictory stances with regard to the status of the deceased employee. Under such circumstances, the matter was remanded to the respondent number 1, Chairman Railway Board, to take appropriate decision with regard to his status. Full stop. Now, what was the MA for?
Yes, deleting the name of chairman and union.
And direction for?
For
appropriate authority. Thereafter, the matter was
main application, they find another MA. At the time of hearing, that is not allowed. You kindly please page 7 of the MA. Kindly the last page 7 for order. With this direction, way is disposed and MA 9/24/2017 for deleting the respondent of 1 stand disposal. There is another application, but the deleting not allowed. Subsequently, they find another application, the deleting the respondent number 1 without giving any opportunity of any.
Where is opportunity? That is another thing. How does it matter?
The same cause of action, they file another application.
Correct. That
last page, page 7, paragraph 8 in the.
you have not challenged that order. That's the problem. Ki bolla? with regard to this status. By order dated, where is that disposal? 240?
240, my lord, annexed P9.
By order dated
21/11/2000.
240, 21/11/2019, who is this respondent?
7, lord.
The seventh respondent, that is Senior Divisional Financial Manager, Northeastern Frontier Railway, Katiyar, took a decision, came to a finding that the entry, that the revised pension order dated dated 21/1/2014 had been inadvertently issued and had been corrected vide pension payment order dated 11/3/2019. Good stuff. Thereafter, the petitioner approached this court inter alia praying for setting aside of the impugned decision of the seventh respondent, impugned decision dated 21/11/2019 of the seventh respondent, and to treat her deceased husband as ESM grade 1 vide revised pension payment order dated 21/1/2014. During the hearing of the petition, a coordinate, it was brought to the notice of, respondent authorities placed on record order dated 3rd September, order dated placed on record order passed in MA 8/20/2019 directing, modifying the earlier order and directing appropriate authority to consider the case of the petition. Full stop. The registry was also directed. Registry tribunal. Was directed to communicate this order to the writ petitioner. Was this order communicated to the writ petitioner? Hmm? MA was allowed that order. Was directed to communicate this order to the writ petitioner. By order dated 10/1/2020, a coordinate bench of this court, presided by a coordinate bench of this court, directed the registry of the tribunal to submit a report indicating the date and manner of communication of the order of the tribunal in MA 820 of 2019. MA 820 of 2019. Till date, no report of the tribunal has been placed on record. This court, therefore, is of the opinion that the order of the tribunal modifying the authority, altering the authority who would decide the case of the petitioner. Now, under such circumstances, we are constrained to hold the authority concerned who was assigned the duty to decide the case of the petitioner had been altered behind his back. It is also relevant to note, had been altered behind his back. Full stop.
If in that case, I may be allowed to seek instructions that we had communicated the order.
We are directing a fresh hearing.
For the entire matter.
The respondent number 7 will take a decision afresh after giving an opportunity of hearing to the petition. It is useless to keep it. So let him be satisfied, because we are satisfied that the decision can be taken by respondent number 7 as the appropriate authority. However, to dissuade any feeling of a decision being taken behind his back, let him be given a fresh opportunity to present his case before the 7th respondent. All right, that's the best we can do for you. We are modifying this order. The chairman railway board need not hear you. The seventh respondent is good enough to hear you. Why should the chairman railway board give you a hearing? Tell us. By the papers, relevant papers, documents are with the seventh respondent. Well, behind the back of the petitioner. This was wholly unjustified and uncalled for. Full stop. Accordingly, we direct the first respondent. Accordingly, we direct that the decision of the impugned decision, dated 21/11/2019, taken by the seventh respondent, shall be kept in abeyance. The issue shall be decided by the first respondent, Chairman Railway Board, in terms of the direction passed by the tribunal. Full stop. Decision shall be taken within 6 weeks from date.
My lord, if this matter is referred to respondent number 1, it will take much more longer time, the chairman to take up such a isolated matter. Respondent number 7 can very well be followed because he is the person who had issued the picture. And he is the head of the division.
If his satisfaction is the respondent number 1 takes it, please let respondent number 1 take it.
My lord, then the time frame.
3 months.
Little more, my lord.
Cannot. It is impossible.
Yes, my lord, let it be 4 months. My lord, then one additional maybe given to us that the chairman may delegate the power of hearing.
To whom?
To any of the respondents.
Tell us, give a pragmatic view as to whom you agree to take the decision. The chairman railway board, in our understanding, is an erroneous decision.
The main authority that chairman.
All right. Please, sir, approach a litigation in a practical way. We, in the face of the material, we do not find any arguable case for your client. You want a rehearing, we can give you a rehearing. It would be pragmatic if we give it to an authority who is ordinarily dealing with these matters instead of the railway board.
Lordship, if I am to permit it, my lord, respondent number 6 is the best person. He is the highest authority in the division. Divisional railway manager personnel.
Yes. Achha. This was only on. কি বললাম আগের লাইনটা ওইটা কেটে দিও তার আগে কি বলেছি আগের লাইনটা where the decision is unauthorized.
This will present the case, but under such circumstances, we are constrained to hold the authority concerned who was assigned to aid to decide the case of petitioner at one point that behind his back.
Behind his back. This was wholly unjustified. However, and at the same time, we are of the view the direction upon the first respondent, that is Chairman Railway Board, to take a decision with regard in the matter would would lead to unnecessary delay. Unnecessary delay. The said authority, unnecessary delay. On the other hand, unnecessary delay and dilation. Under such circumstances, we direct as follows: the impugned decision taken by the seventh respondent shall be kept in abeyance. The matter issue shall be issue whether the husband of the petitioner, namely late so and so, had superannuated in the status of GSM, ESM Group 1 or Group 2 shall be decided by the divisional railway manager.
Respondent number 6.
There is no division railway manager personnel. There is only
Bracket, my lord, what's the in bracket P, capital P?
that is respondent number 2.
6, lordship.
6. Here is not bracket P.
Lordship in the order, এখানে করেছি।
In the writ petition he is not given that. Division Railway Manager bracket P, Northeast Frontier Railway Katiyar, Bihar, who is the senior most officer in the organization, who is the relevant officer, who is the senior most officer in the organization, who in the division, who deals with the service conditions of the employees of the said division. Would stop. Such decision shall be taken within 6 weeks from date, and pursuant to the decision, any further action, pursuant to the decision, all further action shall be further action, if any, further action shall be taken in terms of the order passed by the tribunal dated 3/9/2019. With these directions, the writ petition is disposed of. কিছু দেয়া গেল কিছু নেই আবার একটা round of litigation. Yes, next matter.
Praying for next circuit from respondent. Learned advocate Kalyan Sarkar is not well. He is
On the
out.
prayer of the respondent.
My lord, there is a contempt application pending against us. 15/12.
Learned advocate for the respondent writ petitioner seeks adjournment. Learned Deputy Solicitor General contends a contempt petition is pending. In light of the assurance that the writ petitioner shall not pursue the contempt application, the hearing of the matter is adjourned till the next circuit. Do not pursue with the contempt application.
My lord, only one line, liberty. We have submitted the affidavit of service.
Affidavit service has been placed on the.
Get
Next. Nobody. Nobody appears. Next circuit. Same.
I beg to appear on behalf of the petitioner appellant led by Mr. Shonak Bhattacharya. He's appearing virtually.
Lord, I appear for the, my lord, there are two appeals in the list. My lord, I am audible, my lord.
Yes, you
I am for the respondent number 1, my lord. Both the matters, my lord, but today I have received the affidavit in reply in this morning. So, my lord, kindly
My
allow
lord,
me the.
it was served upon her, my learned friend at least 15 days
No,
back.
no, my
She
lord,
took
I
the
can show you
same
a lot.
plea,
I
my
can
lord,
show you a lot
on the
in WhatsApp. In the
circuit, my
WhatsApp, I have
lord, in the
received
last circuit, she
timing.
took the same plea.
No, I have received in the morning at 9. I have received the reply, my lord.
My lord, may I
Kindly
just say this, my lord?
accommodate
From that may be from her client, but we have served it long back.
No, my lord, no. Today I have received, my lord, affidavit in reply. Kindly accommodate 1 week time.
My lord, this has been going on from the last circuit.
Exactly.
My lord, either they say reply or they say settlement. My lord, settlement, we have got nothing to do with settlement. There is no scope of any settlement. My lord,
But I
kindly,
can show
and
your
my lord,
lordship, I have several documents, my lord. They approached us for
they
settlement.
have been, my lord, they have
They
been,
are ready to pay for 1 crore 14 lakhs. We are saying no, we are entitled to get the 1.44 lakhs. Only dispute as regard to the quantum. I can show you lordship. There are so many documents there. One at they are talking about the settlement. Another at they are pressing for appeal. My lord, this is not fair, my lord. My lord, I was under impression, my lord, the matter will be settled out of court. That is the reason I could not get ready with the matter. Now they are pressing for appeal. My lord, I can show you, lordship. I have several documents where they have approached for settlement. Their own documents.
my lord, they are enjoying an interim order in a proceeding which is not maintainable.
No, interim order got by them. They are appeal. They got the status quo.
My lord, kindly have a look at the interim. If I had got
My
status
lord,
quo, would
today
have
I
been
am
an
not
appeal.
ready, my lord. Today I am not ready because my instruction is, my lord, they approached us for settlement, only dispute as regard to the quantum.
But kindly takes it up tomorrow only. Kindly takes it up tomorrow itself.
No, my lord,
Yes,
tomorrow.
My lord, I'm
Starting
appearing,
to go there.
I'm appearing for the respondent number 2.
My lord,
And
it is
in one of
being
the
discussed
matters,
for
we have
today
not
and
been
tomorrow.
served at all. I'm for the respondent number 2, and in one of the matters, we have not been served at all. It's only because of the other matter that we are aware of the fact that this FM 83 of
What are you
2023.
saying? What are you showing?
We are for respondent number 2, Kanchan Cinema. We have not been served at all.
Right.
In
Kindly,
FM 83.
my lord, kind enough to
My
look
lord,
at the
kindly
order
have a
dated 13th June,
This is
13th June
despite directions
2023
of the Honorable Court.
passed by the coordinate bench of your lordship. 13th June 2023.
Yes.
So the appeal is against an order of injunction.
Yes, my lord. There are two appeals, FM 83 and
Right.
FM 84.
Right.
FM 83, my lord, I am appearing, my lord, and FM 84, I suppose Mr. Bose is appearing.
My lord, I
For
am.
the
I
appellant.
am. I
Right.
am.
So,
My lord, kindly have a look at the impugned order, my lord.
the order is against an order of, the appeal is against an order of injunction. Passed
My
on
lord,
the-
passed in a section 9 application.
Right.
My lord, I am paying some accommodation, my lord. Today I am not ready, my lord. Kindly accommodate some time, my lord.
We
Because
have heard you, madam. Don't go on shouting.
Today I have received the report,
We
my lord.
have heard you. So please do not interfere with the proceeding. We'll decide whether we will give you an adjournment after hearing the appellants. Yes.
My lord, I have a
What's the matter?
preliminary objection, my lord. Your lordship will kindly see.
You are appearing for the appellant.
My lord, I am appearing
Right.
for the appellant.
Matter has been referred to arbitration.
No, my lord,
No,
that's
yes,
my
that
first
is the
point.
point.
My
Yes.
lord, section 9, pre-reference section 9 application filed in the year 2021. Section 9 application disposed of, we are in appeal till date. Well, the petitioner
steps
in
have
the
been taken?
nothing whatsoever. And
No
my lord,
section 21
We'll
notice.
vacate the interim order on that ground.
my lord. My lord, this is exactly
Yes,
what
who are for the respondents?
My lord,
Only
I
the-
am for the respondent,
Yes,
my
now,
lord. Yes.
Madam, listen to us. By Wednesday, give us information whether your clients have referred the dispute to arbitration or not.
May I make one
My lord,
submission?
we have sought notice under section 21 within the 90 days. But problem is that, my lord, in the meantime, they are approached us for settlement. So we are on the
We
line
have
for
asked
settlement.
you only one thing, whether you have referred the matter for arbitration or not. If you have not, on that ground that you are not willing to
No, my
proceed
lord,
for
that-
arbitration, we will vacate the interim order.
No, my lord, then my lord, can you fix the date for hearings on that date, my lord? I will argue on that point. Kindly fix the date, my lord.
Kindly takes
What
it up on
point are you
Wednesday.
going to argue?
Because, my lord, they are misleading the court, my lord. Today I am not ready, my lord. Kindly accommodate the date and fix the date. On that date, I will be there.
2
I want to.
years you are enjoying an order of injunction, you have not referred the matter for arbitration. You have
No,
not
my
taken.
lord, this is not correct, my lord.
So place on
My lord,
record,
No, no, my lord, kindly
instead of
appreciate.
shouting, listen to us. Place on record steps taken by you to refer the matter to arbitration.
No, my lord, I kindly appreciate, my lord, the law is very clear. The matter should be we have to serve the notice under section 21 within 90 days. I have done it. I have done it, but dedication is there within 3 years. I can move for section 11. But problem is that, my lord, they have refused to.
So that 3 years is over.
No, my lord, 3 years not yet over, my lord. In the meantime, they have approached us for settlement. My lord, kindly appreciate.
Settlement has got nothing to do with this.
No,
If you-
my lord, I can show you the lawsuit, my lord. I have several documents. They approached us for the settlement. We are on that. We are under impression that matter is going to be settled. So no need to go for arbitration. That is our
Then we'll
problem,
vacate the interim order. We'll vacate the interim order since there is no need to go for arbitration.
No, my
An
lord, because
injunction in contemplation of arbitration is unnecessary.
No, my lord, kindly appreciate, kindly
So
appreciate.
please, madam, settlement has got
Then, my lord, kindly fix the date. Kindly fix the date, my lord.
day after tomorrow. Place on record steps taken by you to go for arbitration. If you are unable to do so, we will vacate the order on the point that you are recalcitrant and not willing to go for arbitration.
But my lord, problem is that they have created the problem. They approached
We
us.
are not bothered who has created the problem. You have obtained an injunction. It is your duty to proceed for arbitration.
Yes, I have proceeded, my lord,
Injunction gets
section
vacated.
21. As
Yes,
and when I
injunction.
have
All right, please don't go on shouting.
21. As and
Don't
when
go
I have
on
got the-
shouting.
No,
Be
my lord,
kind
kindly
enough, ask your junior to place on record steps taken by you to go for arbitration.
My lord, I will be there on Wednesday. I'll be there, my lord.
Yes. Learned counsels for the appellants content. Respondent has not taken steps to refer the matter to for arbitration. Learned counsel for respondent seek time to clarify the position. Matter is
My lord,
on
my
Wednesday.
lord, one indulgence, my lord. The problem is that for going there because of the ticket problem, my lord, this is the crisis.
Madam, all these lectures will not do. We have not asked you to come. We
But
have
problem
asked you
inundation
to
of papers, my lord, inundation of papers. It is not possible for to argue on
inundation
that.
of papers. We do not understand. We understand inundation by water. What we want is documents furnished by you that you have referred or taken steps for referring
My
the
lord,
matter to
kindly
arbitration.
see the record. My lord, kindly see the record in the court record. Original section 21 notice and the postal receipt is
So
there.
ask your junior to assist us and place on record that paper.
My lord,
Send
original postal receipt and section 21 notice is in the record, court record. Last occasion I could not
Yes,
return
who is
back.
appearing for the respondents?
Last occasion I appeared and I personally appeared. I handed over to the court, but I could not get back that because I forgotten to take back that.
If you have forgotten to take back that, you have
But that-
photocopies. You have
That is lying in
photocopies.
the court record, my lord. Kindly see the court record
You
section.
have
21.
photocopies of what is right.
That is with me, but original is lying with
Please
the
see,
government
please
court
examine whether it is there in the court records.
record. Yes, my lord. Post
Well, there are
original
6
section.
respondents. If a section 21 notice is issued, the 6 respondents in the arbitration agreement has to be served. So all the 6 respondents are before your lordship. They are saying that none of them has been served. So if there is no service of a section 21 notice, the act contemplates service.
No, my lord. They have also given reply to the notice of section 21.
Correct.
What
Let
is
us
she
see the
saying?
papers. Let us see the papers. If they are there, very good. If they are not there, that's okay.
My lord, original is lying with your my lord's
We
record.
don't require original. Just send the fax copy. Send it through
Then
mail.
my lord, Wednesday I'll be there, my lord.
We don't ask you to be there. We want the document before us.
But there is no junior in from my side, my
No
lord. So that is
difficulty,
my only
madam.
comment.
Please scan the document and send it to us. Place it before us.
My lord, actually, I'm not well acquainted with that scanning.
And no, but she can give it to
Well,
us, my lord. We are here. Wherever
So-
she is doing it from, we are sitting
So I
beside her.
hand
She
them
can
over
give it
to the
us.
learned lawyer,
Yes,
for
yes.
learned advocate on record for the appellants.
Absolutely, absolutely. She can hand
My
it
lord,
over to
kindly-
us.
My lord,
We'll
kindly
accept
record
service.
their submission. They have not received the section 21 notice. Kindly record their submission.
We will not record any submission. We have asked you to do a thing. We expect you to do that thing.
Yes, my lord, I will be there on Wednesday.
We are not concerned whether you are there or not. We are concerned whether you have taken steps under section 21. You
Yes,
sure?
my lord, I have taken steps under section 21.
We'll
they have
adjourn
given
this
reply.
matter till the next circuit. Simple.
Yes, my lord, I am grateful.
Well, that is exactly what she wants. Well, she said the same thing before the previous circuit bench.
No,
That's
no, I
why-
don't have any intention.
And
my
well,
lord.
kindly keep it on Wednesday.
Madam, we are very pained to see the immature manner in which councils are addressing us in this proceeding. We are not accustomed to this shouting matches.
But my lord, kindly appreciate they have sold my property. They are enjoying my
And
money.
unfortunately, you are not actually helping your litigant, your client. The way you are coming across is actually irritating us, which may prompt us to take an adverse stance against your client. So please be very careful in the manner in which you address the court. We're keeping it on Wednesday. We expect a clarification with regard to reference.
Lord, may I submit one thing? Client has specifically sent me even there are no talks going on.
We are not bothered about settlement talks. We want whether the respondents have referred the matter or taken steps of notice for arbitration.
I'm grateful.
Strange.
So item number 58, I appear for the appellant.
I am appearing here of the appellant.
Am I audible to my lords?
Yes.
Lords, I appear for the Health University, my lords, in this matter led by Mr. Devokil on the mighty. Lordships, this is an appeal, my lordships, against an order dated November 4, 2019, my lord.
Right.
Subsequently, if my lordships kindly take the order dated 12th March 2021.
What is the status of the course now?
My lordship, the student,
In March 24, there is final examination of the batch.
Of that batch. And he has not taken any of the exam tests because of
Yeah, we have a question because in your paper book, there is an order that Mr. S.S. Banerjee appeared before the circuit bench and first order that on February 2021. That is, we should take their recognition and candidates should not be disqualified out of all these societies. We have taken some initiative.
They took the examinations. They have taken.
But we did not publish the full result. We are just informed that they are passed or not. We inform them the pass and they can proceed for the next.
University. You are for the university. Now, who is appearing for the respondent students? Mr. Banerjee?
Mr. Banerjee was for the.
Ah. We need to hear the repetition also.
Actually, maybe serve a notice and come back. Maybe serve a notice and come back.
Because the sort of common order passed in other cases, which do not appear to be similar to the first case, that is 9697 of 2019. In the first case, the candidate was absent and could not participate in the counseling proceeding. Here, these persons were present and they did not take up any objection. After the writ petition was moved by one of these candidates, all these persons have come up.
Yes.
So there's a domino effect here. So please give notice.
But look, in this regard, I can say one thing. In single bench, their admission has been confirmed.
Where their admission is?
They're in this appeal against their provisional admission,
Right.
but
Oh, there were subsequent orders passed by the single judge.
this
Let us see. What is your stance on this?
we just inform them that the appeal is pending. This much.
We will challenge these orders, my lords. We have already instructed the university to challenge these orders, my lords. We have actually, my lords, the problem is that in the management of the university,
you have to challenge these orders.
Yes, my lords. Yes, my lords. We will challenge these orders.
Situation in university because this is not in the state. As per the Honorable Governor's order, and register is in serious ill and admitted in hospital. So in this situation, we are unable to take the immediate action. But
why? Anyone who is acting in place of the VC or the registrar will take the decision.
But it's not stable.
What do you mean to say not stable? This is day-to-day activity. Salaries are paid to the employees. Salaries are paid, yes or no?
Yes.
Then if salary is paid, then steps have to be taken. We would have understood all the employees of West Bengal Health Science, salaries are not being paid, they may not work. But if the salaries are paid, we would expect steps to be taken. It smells of connivance. An interim order is passed and all of you are allowing the interim order to consolidate.
No, madam.
Yes, sir.
Madam, we have communicated to the university. Madam, the letters are also there regarding our communication, madam.
Huh?
We have immediately, madam, after the what happened, madam.
This order is passed in August. We are in December.
Immediately.
If let us say the university had been closed down, you would have appealed against this order. You allow this order to, and this order is passed without notice to the, without hearing the Medical Council of India. Then
that is a completely wrong order. What has been passed by the single judge?
We don't know. We are not expressing any opinion, Mr. Agarwal, because this order is not under challenge before us.
Which is actually what happened. The junior who was appearing on that date before the learned single judge, she could not place before the learned single judge the orders passed by this honorable division bench of 12th March 2020. If that order would have been placed before the learned single judge, this order could not have been passed. So, we are taking.
Don't know. Then what steps have you taken?
We have communicated to the university management. We will file the appeal at the earliest management.
By the time they complete their 5-year course.
No, management. We will not allow management them to complete the course. Management. We will.
Already completed. Your final examination is to be held maybe next year.
Management may pass a restraining order, management, to that effect, which will also help us.
We are informed the learned council for the appellant submit. By a subsequent order, the provisional admission of the respondent student has been confirmed. Steps are being taken to appeal against the said order. Under such circumstances, fresh notice be issued upon the respondent writ petitioner. Let these matters be heard in view of the writ petitioner adjourned till the next session.
But in last position, lordship said the state is the state is not a party.
Not a party?
Not a party. Not a party. The health university, register and the medical council are the party. I have examined.
No, don't know.
Yes, get one.
Very good. Same. Okay. $61.
Half of the state. My lord, in this
Yes,
case,
Hillol Shah Poddar.
my lord, in this case, what I have is I have misplaced the paper book, but I have made a note, my lord. Before that, I have made a written note. So I have misplaced. I think within a day or two, I'll get it. Even then, I'm ready. I can. Required, I can. Yeah, sure, carry on. Yeah, carry on.
অর্ধেক করে দিচ্ছ না কেন? ফাইলগুলো দাও। Where is exhibit A? Olha, Bibi. Yeah. এটা exhibit A নাকি? বললো আগে আপনি বলেছে 26 বুঝতে পারছি না। Alia was accused.
My lord.
Is the complainant.
Huh?
She is the complainant.
She was the complainant. When this statement was made, was she an accused? Huh?
The basis of confessional statement.
No. On the after the other accused persons were arrested, on the basis of their statement, it revealed that she was involved in this crime. She has opened the door.
Who said she had opened the door?
My lord. Now I've made the written notes, my lord.
And it's the reposition of PW.
After he finishes, then.
I relaxed by the learned.
So you admit you were in the room. There was someone called your husband. You opened the door. This person's face were covered, and they tied you and murdered your husband. Right? This is and left. Now this is the 164 statement that you made before magistrate. And before police, you made some other statement. PW4, let us see. This person was also convicted.
All other, some person were absconded and trial separated and they absconded and all other accused charges can take it from
Against Alia, what are the pieces of evidence? Tell us.
It stated that one co-accused, namely Soiful, was arrested before and they came to the police station and at their presence Soiful stated that on the certain day caller came to the house and to backside of the room. So they pushed the door and they entered and they committed murder. And I connivance that according to prosecution that door was pushed and I opened the door or door was pushed and all the accused entered. This is the one connivance. This is the only basis of immediately I informed the incident PW2 and PW.
One second. Let us understand. Did Soiful say anything against you? Five also same. Five also same about Soiful. All right. Seven is Soiful.
5, 6.
Once again, Mr. Chakraborty, sit down. Then we will see. Then what else is there against you? Huh? Huh?
And this call was made to one accused, namely Hamid. He also one out
Very good. Then Hamidul, where is Hamidul? Hamidul is not there. Split. Now who says Hamidul was there? Yes, now Mr. Chakraborty.
Lord, Hamidul is the
Achha,
son-
who has implicated Hamidul?
Hamidul is Saiful. Now, Hamidul is the son of this
Who has implicated Hamidul?
from the statement of son.
So,
My lord.
Soiful is a co-accused.
My lord.
So can this evidence be used against Hamidul? Let us say Hamidul was tried
They
together.
were called in the call register. They were before the
Forget,
incident.
call will come later on.
My lord.
Call will come later on. From you, what call register you have got? Alia contacted
With Hamidul.
Hamidul. Alia
That is what-
contacted Soiful.
No, Arya contacted with Hamidul.
Soiful Hamidul have call register. Did you?
No.
Huh?
No,
What no?
that was not collected.
That was not collected.
This is the
So
actual-
Alia, so Hamidul is son of Alia.
My lord.
So if there are phone calls between son and mother, until and unless you show son contacted Soiful or Alia contacted Soiful, how the triangulation takes place? Let us say three of us are alleged to have committed murder. You are related to me as brother, right? He gets caught and he says you were involved in the murder, and you collect phone calls where you and me have made communication. The communications can always be explained away because of the nature of relationship there, isn't it?
No.
One. Two, if the phone call is kept apart, or the law is, when you see the statement of a co-accused, the law is keep apart the statement of the co-accused. What remains against Alia? She was present in the place of occurrence. Death took place. She gave an explanation. Was that explanation improbable or absurd?
Right.
Number. These are the three materials. And finally, the material is telephone call between him, herself, and the son. Son has not been put on trial. The implication of the son is nothing but a statement of a co-accused or a person who is there. So first, the phone call itself will not make it an incriminating circumstance. The other two incriminating circumstances, presence and her explanation. You have to show to us how the explanation of Alia with regard to the death of her husband is so absurd that you can take out a circumstance of a false explanation given for death.
Saiful and Alia baby, they are from the same same village, my lord.
Maybe so many people are from
Same, no, from the same Alia's patrimonial house, and the house of the this accused Saiful is the same village. So that is one of the reasons. Second is the door was closed, open from inside. And this what they have taken that she was unconscious for 3 hours. Is it possible? From an assault, can a person be
Out of trauma, she can be always there. It's not that absurd that someone is.
They have taken another ground that regarding the two of the prosecution witness has not been examined. So they are the kind of DW they could have added those.
That is not really.
They could have bring those witnesses before the
That
court.
is not really important.
They are from the same village, Jalpaiguri, Assam. It cannot be a case of that it was ransacked, there was a attempt for committing dacoity. These are not the case. This is a pre-planned matter where there was a conversation with Hamidul, and Hamidul is a person who is associated with Saiful. Now,
That
it's a very-
association foundation is only co-accused.
What the statement, but other witnesses, there are circumstantial witnesses which have made a chain in this case, my lord. It's a complete chain,
Show
my lord.
us what is the evidence of other witnesses.
My lord.
Did they say that Hamidul and Soiful were seen together?
this PW4, PW5, they all stated that they pushed the door and the wife of the elder brother, they opened the door. Now,
she also gave an explanation that I heard a voice which was similar.
the voice was known to her. Without a known voice, a lady will not open the door at night.
Husband was also there.
And it was, they were calling, then the husband was sleeping.
Only. So
husband was sleeping.
Someone woke up, the lady woke up, the husband didn't wake up.
No. I was on his bed, and at that time,
Both were in bed.
Wife
were
was
in
watching TV, Bengali movie.
Right.
He was watching television, my lord.
So he was
If
not
my lord
sleeping.
goes to my written notes, I have made it.
Let us read your written notes.
No, the complainant was not present at the time of
She
occurrence.
was there.
Complainant.
Yes.
Who was the complainant?
Alia
Wife.
Bibi.
Wife.
Complainant was not present. No statement has been challenged by the defense, my lord. We have just denied the prosecution person, nothing else.
So who opened the door?
Alia Bibi.
No. FIR says brother opened the door, victim opened the door. You have made your submission. Brother opened the door as per FIR. See the FIR page 2. You don't have the paper book, right?
Yes.
All right, you take the paper book, we'll keep it tomorrow.
My lord, okay.
Tomorrow? No problem.
Yesterday.
Hey.
So complainant was the you have
Shakuntala,
state
take a photocopy of the paper book, give it to
That's
Mr.
a
Chakraborty.
APP sir. The complainant was the Alia Bibi.
No.
Jahangir Hussain.
Jahangir the bhai.
Brother.
Victimটার ভাই। সে বলছে কি brother opened the door।
Brother
তাহলে
opened-
আলিয়া door open করলো কোথায়?
And there is
Mr. Chakraborty,
Sure.
My lord.
go through the
Now, my question was on previous question that Jahangir Hussain was not at the spot at the time of
Brother's three letter. Brother's three.
You please
Fully
give answer to my questions.
My lord.
What was my previous question was that the complainant was not present at the time of occurrence. How we have come to know about this fact?
My lord, I'll just go through the picture.
No, you have to answer.
My lord, I'll answer.
That was my first question. How he have come to those facts when he was not present?
Sister-in-law বলছে আলিয়া ওকে বলেছে আলিয়া ওইভাবে বলেছে So go through it, Mr.
My
Chakraborty,
lord.
and address us because we find your evidence against Alia are based on few circumstances. One, admittedly she is present.
My lord.
He comes out with the manner and circumstances of death resulting in FIR. Then someone is arrested and it is said by PW4, 5 and 7 that in custody the co-accused divulged the involvement of Alia. Right? Now, there are two difficulties in relying on that statement because the co-accused was before a police officer and therefore the confession is inadmissible. It cannot be inadmissible so far as the accused is concerned, but admissible against co-accused because the confession is a confession, not exculpatory, it is inculpatory confession involving both. Now, even if it was admissible, it is a corroborative piece of evidence. The evidence, it must corroborate the other evidence. What are the other pieces of evidence? Alia is present. Alia explained that unknown people came from outside, door was open and they were masked. They tied her up, killed his wife, the husband. She became unconscious. Now, there is nothing on record to really improbabilize Alia's version, apart from this statement of this co-accused. You understand what we are trying to say? Try to collect or indicate from the evidence that Alia's version is inherently impossible. Then we can believe you have made out another circumstance of a false explanation with regard to cause of death. Understand?
And the seizure list, we go through whether there is 2 pieces of rope or not. The 2 persons have been tied up. Okay, this is a very vital thing. Only one nylon.
That was used to strangulate him. So
Why is a rope of tying down the
that is absolutely-
Alia
that is-
Bibi?
that is a false. She was not tied.
এখান থেকে একটা ফটোকপি করো করে মিশ্র চোখা or let's call the other matters for the hearing for the hearing. Not today.
53,
Same.
54 and 55.
Same.
On the state.
Urgent for the day.
53.
66. Urgent for the day.
67.
Appellant. Nobody for the state. Urgent. All right. On the prayer. 66 who is there? 67 who is there? All right.
66.
Urgent for the day. 68.
67. 67 I'm here.
Yes, we are adjourning it for the day. 68.
68 I'm for the appellant.
State. Nobody appears for the state. Adjourn for the day.
59.
I'm for the petition.
All right, we adjourn it for the day. On the prayer parties adjourn for the day. Next.
70.
I seek leave, Milord, to curate this mistake in the paper book, Milord. The entire content of the application is different, Milord, in the paper book, Milord.
You don't understand what you are saying. What do you want, 70?
I want this leave from the court to correct the same, Milord.
You make an application.
Milord, before the court, Milord.
So where else? What do you want? When do you want?
Next circuit.
Next circuit. Next.
71 I'm for the petition.
Nobody for the state. Adjourn for this week.
72 I'm for the statement.
Nobody for appellant. Next circuit.
73.
Next circuit on the prayer of the appellant.
74.
Item 74 I'm praying for next.
Next circuit on the prayer of the appellant. 75.
75.
Lord, I appear for the
For next circuit.
75.
The matter has already finally been served on us on last Friday evening.
They are asking for next circuit.
My lord, I had already, if your lordship may recall, we had indicated that there is grave urgency in the matter because the subject property has been alienated and we have filed applications. We were only praying for hearing of those interim applications for addition of those subsequent purchases as parties in this appeal.
That can be added.
Yes.
And for passing necessary injunction orders so that they cannot alienate it any further to avoid any multiplicity of proceedings. Lordship had fixed today's date as the next date for hearing of those applications, lordship, but we have received an adjournment notice, notice for requesting for adjournment on Saturday, and they are asking that their senior counsel will not be available today and tomorrow. Hence, my lordship, we are not there physically. Otherwise, we had our tickets booked and everything to come and.
Let us, you have asked for an adjournment for 2 days.
Lordship.
Yes.
Correct? So let us keep it on Wednesday.
Lordship.
Lordship, my problem is Mr. Mukherjee, that is, Gopalda is not available
for hearing.
We do
purpose.
not know Gopal.
SN Mukherjee. So Lordship, he
Lordship, in
only
the
told
letter, they
me
have only
me to take any date after 15. So I can only pray for the next circuit. If your Lordship may kindly.
Can do and
Lordship, when the matter was last taken up, they had not
Let
indicated
us do like this.
that
Wednesday, we are keeping this matter,
Lordship.
not for final hearing,
Lordship.
but for the addition of the parties, that is the subsequent purchasers.
and Lordship for injunction on the subsequent purchasers, Lordship, because
That-
they can 2 and 3 Lordships.
So can I then request for 15? He'll be
No.
reaching. 14. 14 possible, Lordship?
14th is possible.
Kindly.
Thursday.
I'll
Keep
try
it
my
on
luck.
14th.
I'll try my luck.
Yes, 14th.
Grateful.
আমি যাবো বুঝবো ওখানে
But no.